Lord,
Yes.
may I have your lordship's leave to mention one inclusion under heading application, my lord?
Yes. Lord, I have the same
Ready to mention one matter, my lord, for correction in the order, my lord.
correction to be mentioned.
I'm mentioning one upgradation, my lord. My lord, similar order has been passed in this matter, in two matters.
Okay.
May I have your lordship's kind leave to mention a matter for upgradation? My lord, it is appearing as item number 300, a combined monthly list, your lordship. Any day convenient. I mentioned it thrice.
What is the urgency?
The urgency is that this is with regard to a scheme which was floated by the central government and the state government was implementing. There has been some, there is a component of subsidy involved in it, in the loan to be given. The loan has never been given, but the subsidy amount has been disbursed. This is the public interest litigation that has been.
Lordship, may I be permitted to mention a matter for inclusion, your lordship? The urgency is that, your lordship, the KMDA had cancelled a certificate which was issued by KMDA, your lordship. Lordship, thereafter, your lordship.
What is that certificate?
Lordship, this is a certificate which shows part completion of the biomining work. Lordship, that certificate was cancelled. It was not only cancelled, your lordship, I was alleged to have done forge. I've alleged to have obtained the certificate by practicing forgery, your lordship, when the certificate has been issued by the KMDA engineer themselves, your lordship. Lordship, I may kindly direct it to your
We'll
witness.
include it as early as possible.
Lordship, grateful.
Lord, I'm mentioning one urgent matter for upgrading it.
Yes.
For inclusion.
Inclusion. Yes. Inclusion. Yes.
Lordship, with regard to the upgradation, Lordship, it's a CSC appeal, Lordship. Lordship, it was supposed to go. It is appearing in the list, Lordship, with item number 45.
Yes.
Upgradation, my lord, on the ground, my lord, due to illegal filling up of pond, my lord.
Illegal filling.
Yes, my lord, dengue has, my lord, illegal.
Lordship, restoration application.
My lord, it's an upgradation, but it's a field matter to
But
urgent.
in the letter, you have mentioned the urgency.
Urgency I mentioned, my
Yes.
lord. It's
Then please
one
give it.
time dismiss it.
We will go through letter by letter and then
Your lordship,
take the case file and then do it.
your lordship, may I permit to mention a matter for inclusion in the list? This is a public interest litigation. Your lordship, this matter was heard by your lordship on 3rd July 2023 and directed to appear after 2 weeks. Thereafter, no appear.
My lord, may I pray for, my lord, upgradation of one matter, my lord. In this matter, my lord, I have challenged, my lord, the virus of, my lord, Criminal Identification Act, my lord, which is most draconian than, my lord, earlier act of the Prisoner Act. It allows the, my lord, investigating agency to take the signature of
Affidavits have been filed.
my lord.
Affidavit.
No, my lord. Since 2022, it is pending. It is appearing as, my lord, item number 662 of the monthly list, combined monthly list.
Let us see.
Upon notice, I am mentioning, my lord.
Who will appear?
ASG, my lord.
ASG will appear.
Yes, upon notice, I am mentioning, my lord.
Okay.
My lord.
May I have my lord's kind leave to mention item number 48. My lord, this is relating to, my lord, a university laws bill, my lord may remember, my lord, once heard, my lord, I'm led by Mr. Lokhi Kumar Gupta. My lord, the bill is pending before His Excellency, my lord, for about 2 years. And now
So
that
we'll reach today. Let it remain in the list. It's 48. Let us progress. Then.
May I permit to mention one matter, my lord? I have served the notice to the appellant, my lord. I am suffering by the interim order. On my lord, 14 June, my lord, your lordship heard the matter. I pray for 1 day's accommodation. Your lordship fixed the matter on 21st, my lord, and passed an interim order. Kindly see the order. Your lordship directed the same position, my lord. But my lord, matter was got to the
All right.
My lord, may I be permitted to mention one PIL, my lord, for inclusion in the list, my lord.
It is in the running in the monthly list.
No, my lord, it is not in the list, my lord, 2022 matter, my lord.
What is the urgency?
Urgency is this, my lord, I am for the respondent, appearing for the respondent, citing pendency of this writ petition, my lord, the revenue officer makes some changes in the record of right. That's why I am not in a position to transfer my land.
My lord, I am praying for leave to file one matter and move it
Yes,
urgently,
leave
my lord.
granted.
But regarding my lord, today at 2, my lord, I would
You're
like.
also leave granted.
Your lordship, may I be permitted to mention a matter for inclusion in the list, your
What
lordship?
is the urgency?
It's only the hearing is pending, your lordship. Affidavits have
Hearing matter, you please wait. After
My
2
lord.
or 3 weeks.
Lordship, may I be permitted to mention one PIL matter? This is regarding the delimitation that is being done in the by the Hon'ble Municipal Corporation. We have been notified that the Election Commission is going to notify election in 2 to 3 days.
But in fact, you appeared the other day.
Yes. Lordship had given the date for next Monday. Lordship, will kindly
exercise.
hear the matter tomorrow.
No, delimitation exercise, how writ court can interfere?
Lordship will kindly hear the matter tomorrow. We will satisfy your lordship.
Not
My
tomorrow,
lord.
you give the letter, let us see.
My lord, just now I pray for leave, my lord. I would like to move the matter tomorrow, but it's extremely urgent, my lord. Organization like Naxalites and Maoists are operating inside the Jadavpur University and raising slogan of stuff Azadi.
No, you please wait. There are, today, I think the other matters are listed.
But tomorrow, my lord.
It's item number 14 is an analogous matter.
That is,
Analogous
that issue is different, my lord. That issue is probably different.
You
That-
please wait, let, you
Lordship,
hear
may
their
we
At least
permitted to
file
submit
with
the
leave
letter.
to move today, my lord, in the second half.
May
If
we
you kindly
permit to submit a
fix
letter?
matter. If you kindly fix it in the second half, my lord.
Not so, second half is original side. You, leave has been granted, you file it in the department. Please call the list.
My lord, may I have my lord's kindly to mention a matter. My lord had directed us to come after service. The matter was taken up
All
on
right. Service complete?
service complete.
Yes, give the letter.
My lord had passed an order on
Ah.
Wednesday.
Hmm.
It's not on server.
Today it will be.
My lord, one matter for which your lordship has been pleased to grant leave. There has been a rule issued against an contempt. And for that appeal has been preferred. And in the lower court, the matter has been returnable on 25th.
So you, leave has been granted, it will be listed. Fresh matter, it will be listed. Please call.
Appellate side, daily list, serial number 1.
What is this correction? Huh? Yes, sir. Yes, Mr. Kaushal, you are appearing in this matter?
Yes, my lord. Lord, I am appearing for the petitioner.
Yes. So upon your mentioning, we listed the matter on 1st of August.
Yes, my lord.
Advocate General is appearing in the matter.
Yes, my lord, I am there.
I appear for the High Court administration.
It is challenge to the Calcutta High Court contempt of court rules 1975.
As being violative of the Constitution. Article 250.
Affidavits have been filed.
No, my lord. That is the whole difficulty. If your lordship may be pleased to kindly permit them to file affidavits and set it down for hearing at my lord's convenience, my lord, that would be very helpful.
And who are the respondents?
Well, the respondents are basically the Honorable High Court of Calcutta and the state of West Bengal. But your lordship felt, your lordship's predecessor felt that perhaps other parties may also be permitted to be heard. And that is how we are before your lordship.
Now, should the central government also be heard in the matter? Because it's basically a rule framed under the Contempt of Courts Act. I think that.
My lord, may I just clarify one thing, my lord? We are not challenging the entire scheme, neither of the act nor of the rules. We are only requesting your lordship to either strike down or even read down a particular rule which says that a petition for civil contempt, unlike criminal contempt, can be preferred only by a party aggrieved. So that phrase party aggrieved, my lord, is being interpreted by the Honorable Calcutta High Court to mean a party for whose benefit a particular order was passed. Our respectful submission, my lord, is that the phrase has to be read in a wider context, where any member of society who is aggrieved by diminution of the dignity and authority of the honorable courts should be permitted to come forward to acquaint the honorable court on a very simple ratio, my lord. The ratio is this. In any class of proceeding where the honorable court is empowered to act suo motu, in such class of proceedings, my lord, the honorable court can never demand demonstration of locus standi for a messenger to come knocking on its door to go forward to act suo motu. So since it is settled law that even in civil contempt, your lordships can act suo motu. In fact, I have a division bench judgment of DB4, my lord, delivered by the led by Honorable Mr. Justice Harish Tandon, confirming this very fact, that there is no constraint on the court going forward suo motu. So, my lord, the legal proposition therefore gets distilled down into one very simple two-line question. that in a matter where a court is empowered to act suo motu, can the court lay down a rule that restricts the class of messengers that can knock on its door to present information to enable it to go forward suo motu? That apart, my lord, Section 41D of the Specific Reliefs Act bars any court from injuncting any person from initiating a criminal proceeding. Now, my lord, it is settled law that contempt, whether civil or criminal, is a criminal proceeding, though it has been labeled as a proceeding which is sui generis only on account of the fact that the CRPC will not strictly apply. But even if the CRPC will not strictly apply, does not dilute the fact that it is a criminal proceeding. And therefore, since Section 41D prohibits a court, even acting on the judicial side, from injuncting any person from initiating a criminal proceeding, it's my respectful submission. Beg your pardon?
Yes.
It's my respectful submission that therefore on the administrative side, my lord, a rule ought not to have been framed whose interpretation is that only a certain class of persons can initiate a particular kind of criminal proceeding. So this is a short point, my lord, in this whole issue. Otherwise, the rules have been excellently framed. They have survived the test of time.
We'll find out from Learned Advocate General within what time frame they can file their affidavit.
My lord, within 2 weeks, my lord.
2 weeks.
2 weeks.
High Court also. It will be
There
some
may
more
be
time.
some formality.
Because
My lord, the High Court should be even swifter.
all right. The respondents are directed to file their affidavit in opposition within 4 weeks from date. Reply, if any, within 2 weeks thereafter. Let the matter appear under the caption for directions on such and such a date. Deeptesh, you give a date. 4 + 2.
4 to 6 weeks.
What is the date, my lords?
1 second.
কবে হচ্ছে? করে আবার ছুটির বন্ধের মুখে।
What date he gave? Yes.
My lord,
Six-
because I would like to come physically, my lords, for the hearing. So if your lordship may be permitted, may permit a specific date.
No, let it appear on 16th October. On that date, we will fix a date.
To ascertain first.
My lords, could I make a humble request, my lords? Not that there is need to exchange affidavits, my lord, but there are no facts that are required to be controverted. It's only questions of law, but nonetheless, even if they are filing affidavits, if your lordship may set it down for final disposal, my lord, on that date.
No,
it would be-
that may not be possible, sir, because the High Court administration has been made as a party. So let them file their affidavit, either accepting your contention or supporting the rule as it exists, and then we'll take it. So list for directions on 16th. So 16th you may appear online, and thereafter we'll fix a date.
Very well, my lord. Much obliged.
Thank you very much. Thank you. Yes.
My lord, I beg to appear on behalf of the state.
Lord, I am for the petitioner, my lord. Affidavit service. Kindly, please.
Conversion.
My lord,
My lord,
in
in this matter, I have got the instruction, my lord. The instruction is that the private respondents have taken permission from the authority to fill up the equal quantum of land as per proviso 9 of section 17A. And my lord, that is why the permission has already been given.
No, then you challenge that permission.
Lordship, kindly only
No,
1
it-
minute.
My lord, the under
My lord, this is
provisions
an-
of law.
My lord, Lordship, this is an
Compensatory filling up.
My lord, Lordship, kindly, this is an ill connivance with the,
Correct,
my
sir.
lord, number one.
You are not
Number
saying anything on
Number
merits.
2, my lord, this land is relates to municipality, but they have given the quantum of land
We will
in
test.
a Panchayat.
No, we will test the correctness of the order. You please, you give him a copy of that order.
My lord,
You challenge that order. This
My-
this public interest
kindly give them
litigation,
liberty.
this public interest litigation has been filed alleging that the private respondents have illegally filled up a water body. The learned government council, learned additional government pleader, appearing for the respondent, has produced written instructions given by the additional district magistrate and district land and land reforms officer Hooghly, dated 9/8/2023, wherein reference has been made to an order dated 5/6/2023 by which permission / no objection certificate appears to have been granted on certain conditions. Copy of such order has been furnished to the learned advocate for the petitioner. The writ petition stands disposed of, leaving it open to the writ petitioner to challenge the correctness of the said order if so advised. Next.
Grateful, my lord. Highly obliged.
Serial number 3.
Deeply bled, my lord.
Yes.
Well, I am for the petition. Well, these are active service. Well, petitioners and along with my lord 40%, my lord, they are my lord selling, they are making their business, my lord, carrying their business by the side of a heart, my lord, by the side of a road, my lord.
By the side of the
By the side of a heart, market, my lord.
market.
And that is also, my lord, by the side of a road, my lord. My lord, they are doing this business for 40 years, my lord. This is their livelihood, my lord. 30 to 40 years, my lord. Suddenly, my lord, the authority concerned is going to evict them, my lord. They made representation, but my lord, I appreciate, my lord. But my lord, where do I go, my lord? My lord, what happened, my lord? After the my lord, the petition is filed, my lord, the SDO, my lord, called us. Hearing was done, my lord. My lord, kindly adjourn this matter, my lord. He told us that.
No, we will ask the SDO
Yes, my lord.
to consider your representation and do the need.
Yes,
But
my lord.
then roads, road margins, pavements are meant for something else.
My lord, we are ready, my lord.
Block the entire road. In Maulik Bazar, same thing happened. You block the entire road.
No, my lord.
Cars are being dismantled. That is not
My
proper.
lord, we are not blocking the entire road, my lord. We talk to them, my lord. Give a accommodation, alternative accommodation, or my lord, by the side of the road.
Admittedly, the writ petitioners are carrying on their trade and business on road margin, which is
My lord, by the
impermissible
side of
under
the
law.
road, my lord, or not the road. my lord.
The petitioners have the petitioner and others have submitted representation to the authorities.
Yes.
And the learned advocate for the petitioner submitted that the subdivisional officer Kandi,
Yes.
the fifth respondent, has already directed the vendors to appear before him for a hearing. Since the matter is already seized off by the fifth respondent, no direction is required in this writ petition except to observe that it will be open to the fifth respondent to take into consideration the representation given by the petitioner and on his behalf and on behalf of other vendors and proceed to take a decision in accordance with the law. While taking a decision, the fifth respondent should bear in mind that roads and road margins are meant for free movement of the public and the traffic, and there cannot be any hindrance to such activities. Equally so are the pavements which are meant for the pedestrians. With this observation, writ petition disposed of.
My lord, kindly also direct them to consider my lord. We are, my lord, doing business for 40 years, my lord.
Maybe, sir.
My lord, kindly, my lord.
That is for them. If they want to build up a shopping complex for you.
No, we
let
are
them-
not. My lord,
Next.
kindly.
Serial number 4.
Sorry, sir. Next. Serial number
Please, my
4.
lord. This is a public interest litigation, my lord, against my lord indiscriminate way, my lord.
Heavy loaded not to ply on the road.
Yes.
So and so Gram
Yes,
Panchayat.
yes, my lord. This is my lord. On earlier occasion, this honorable court directed my lord district magistrate to consider the representation. Unfortunately, my lord, while considering my lord, he has allowed to ply my lord 6-wheelers, my lord, with load of 12 tons, my lord. As a result, my lord, the lives of the my lord, the villagers, my lord, have become precarious. My lord, day, night, my lord, instead of 12 tons, my lord, it is carrying on 16 tons in indiscriminate way. The roads have been my lord, broken. My lord, huge dust, my lord. There are incidents of casualties also, my lord. Your
So
lords,
where is the order passed by the district magistrate?
yes, my lord, at the last annexure, my lord, at page. My lord, it starts from 180, my lord. The relevant is, my lord, at page 181.
Vehicles up to 6 wheels are allowed to carry 200 cubic feet materials until the closure of the mining guards by the National Green Trip. Openly so and so. Any violation?
I mean, interesting thing is, my lord will find at paragraph 13, I have stated so long, my lord, on earlier occasion, my lord, there are 3 alternative roads. Only 2, my lord, shorten the roads, my lord. They are going through this, my lord, village and all these things, my lord, making the lives of the villagers, my lord, precarious.
What is the width of the village road?
Yes, my lord, 20 feet. 20 feet. But this is the situation where this, it has become unbearable. And the thing is, my lord, my lord knows for indiscriminate, my lord, raising of sands and stones, my lord, from the river. My lord, in some way, my lord, the agricultural land, my lord, beyond the village will become barren.
In the meeting,
Yes,
all of them participated,
yes,
including some political parties, etc.
yes.
Did you not point out that there are
But
two
we
other
had, my lord, if it is not recorded, my lord, the pain was in the hands of the district magistrate.
No, in the representation,
The representation we have stated, my lord, series of representations I have given.
where have you specifically mentioned that there are two other alternate routes?
Yes, my lord, that was stated, my lord, that was stated there. I'm on instruction, I'm submitting, my lord, it was stated.
No, no, you show which are the two alternate routes.
Your lords will kindly come to paragraph 13.
No, in your representation, not in your writ petition.
Last representation, my lord, will kindly come.
Who will appear for the state?
Right, no, my lord.
Service
Yes,
complete?
yes, service complete. I have handed over this affidavit of service, my lord.
Served? Who's not served?
Here the receipt is also there, my lord. My lord will find all the receipts.
Item it says item dispatch.
No, no, first receipt, my lord will kindly see.
Second receipt, you please see. First receipt may be. You give notice to the office of the government pleader.
Yes, my lord will
as well as to the standing
my lord,
council.
see, this is the receipt.
But nobody from the government pleader's office is here. Is anybody here, government council?
Mr.
Ganguly is there. You please get some instruction in this. They are saying that heavy six-wheeler trucks are plying through a 20 feet Panchayat road, carrying minerals, etc., damaging the life. There is some order passed by the
Bones and sands, my lord,
by the block development officer. But then in this, you have not pointed out. You should have given a map.
We have, my lord, I can show, my lord, series of representations.
No. You please immediately point out series of representation. The 180 pages are annexed to the state petition. So and so, we have requested so and so learned government advocate to accept notice on behalf of the state respondents. Let notice be served on the standing council for the pollution control board and other standing councils of the other respondents. The petitioners shall file a supplementary affidavit clearly setting out as to what are the two alternate routes which according to the petitioner is available for the heavily loaded trucks to ply. The affidavit should be supported by a plan. List the matter after 3 weeks. Next.
Serial number 5.
Give a date. You don't give a date.
I will have the state in this matter.
11th to 15th. That week you keep it to 3. 11 to 15, don't give it. September.
Let's see if I, on behalf of the petitioner, I'm paying for not today.
Why?
Item number 5. Let's see.
Why, sir? What is the prayer?
Its matter relates to, my lord, the house of Deshbandhu Chittaranjan Das is Darjeeling. According to them, my lord, that the museum therein, my lord, has been closed. Now the fact remains, my lord, because of the condition of the house, my lord, it has been closure has been made. Now, my lord, so far the government is concerned, my lord, the concerned ADM, I had a talk with him and he sent me the details. She has sent a document to the, my lord, before the additional chief secretary, North Bengal Development Department, for sanctioning of funds for the purpose of repairing of the
repair and restoration.
Repairing, yes, my lord, for all this. My lord, may I have handed up this document?
Then you please do that and then open the museum.
Lordship, exactly. So only thing I beseech to is Lordship, my lord, that let the direction may be given to that ADM, my lord, ADI, so that, my lord, he can expeditely release the fund and we shall start the renovation work. The entire detailed project report has been submitted.
No, the funds have to be sanctioned by the government.
Lordship.
And the district magistrate has already addressed the additional chief secretary.
Lordship. With the details of the, my lord, the work has to be done. my lord.
Please come. By this public interest litigation, the petitioner has flagged a very important issue, wherein the petitioner seeks for appropriate directions upon the respondent number 1 to immediately declare the heritage house of Deshbandhu Chittaranjan Das, within bracket CR Das, within a fixed period, and to ensure that the house is renovated and repaired, and the museum which was established therein should be thrown open to the public. The learned government council has produced written instructions given by the district magistrate and collector Darjeeling, dated 18/8/2023. In the said written instruction, there are annexures, and we find that the district magistrate Darjeeling, by memo dated 28/7/2023, has addressed the additional chief secretary to the government of West Bengal, North Bengal Development Department, Jalpaiguri, for administrative approval and fund requisition for the purpose of restoration and renovation of the said house. The said communication reads as follows. So page 2. Considering the fact that the heritage of the state has to be preserved, the government should take a proactive step in the matter, and immediate sanction of funds and immediate administrative approval and sanction of funds are to be made by the government on top priority basis. In the light of the above, we would direct the additional chief secretary to the government of West Bengal, North Bengal Development Department, Jalpaiguri, who has not been implemented as a respondent in this writ petition, to immediately take further steps based on the request made by the district magistrate Darjeeling, dated 28/7/2023, and grant the administrative approval and sanction the funds sought for as expeditiously as possible, preferably within a period of 12 weeks from the date of receipt of the server copy of this order. Let a copy of this order be communicated to the additional chief secretary to the government of West Bengal, North Bengal Development Department, branch secretariat, Jalpaiguri 734105, for due compliance of the directions issued here and above. Disposed of. Next.
Serial number 6.
Yes.
I beg to appear for the private respondent.
My lord, I am on behalf of the petitioner.
Preliminary point of mentality of the PIL.
My lord, may I?
Yes, sir.
My lord, this is an application under the Prevention of Corruption Act for the disproportionate of assets of a public servant, a MLA of West Bengal, who is in his chair for the last 2 years. My lord, the proliferation of his properties in the last 2 years questions the very pecuniary resources of his income. He has purchased several properties in his name, in the name of his wife, in the name of his 2 daughters, in the name of his brother, and the totaling.
No, have you lodged a complaint? A formal
My lord, we have placed a representation before
No,
the
no,
concerned
not a-
authorities.
There is a difference between a representation and a complaint.
complaint, in the nature of complaint, my lord.
You sought for a direction upon a central agency
My lord.
and the income tax department to conduct an independent inquiry. Before that, what steps have you taken?
My lord,
Have you
prior to
lodged
that,
a formal complaint?
yes, we have lodged a formal
This
complaint.
representation,
Lord, we have lodged a formal complaint.
No, no,
My
formal
wrong
complaint.
choice of words, my lord.
Formal complaint before which authority?
Before the director of Central Bureau of Investigation, before the director of Enforcement Directorate, because there is no means to place a complaint before the state authorities, my lords, when he is running the state government.
No, you can't say that, no. The
My
criminal
lord,
law.
under the Prevention of Corruption Act, the state police authorities have no jurisdiction to try this matter, my lord.
Why?
My lord?
According to you, if the particular person has amassed wealth,
Hmm.
has plundered the public exchequer, why can't the machinery available in the state, legal machinery available in the state cannot be initiated?
That is not the allegation. That is not the allegation. Allegation is evasion of stamp duty.
My lord, that is not made over here. That is one of the issues.
Kindly read the
That is one of the issues. There
No,
is,
you don't bypass the normal channel.
my lord.
There is a code of criminal procedure which prescribes how a complaint needs to be lodged. Straight away, you file a PIL and you say you
My
conduct
lord,
an
this
inquiry.
is specifically under the Prevention of Corruption Act,
We
my
are
lord.
not worried about what is the position he is occupying. We are only worried about the third respondent who is a private individual. And you are, who are you?
Well,
My
can
lord-
we come to page 17? It will appear who is he. Page 17.
So this appears to be a political.
My lord, the political platform, you are using the political, no such individual in this state has the guts to fight against this kind of.
You lodge a complaint, sir. If suppose.
My lord, kindly give us some
if
direction so that
authority
I can.
Doesn't take action, 200 CRPC is there. If they don't take action, there are ways and means. We are not here to.
There is
advise.
no way for to file 156 clause 3, my lord, if they refuse, my lord, under the Prevention of Corruption Act. That is our only concern, my lord.
But based on this
My
representation.
lord, there is no provision under prevention of,
we can't-
under the 156 clause 3. If they refuse to lodge the FIR, there is no alternative option for us, my lord.
You please pursue your remedies under the CRPC that provides for sufficient safeguards. We can't.
My
We have
lord, then
already-
also,
we
there
have
is a
already
problem.
passed 2 judgments where we have said that this short circuit will not occur. A writ of mandamus cannot be issued. In one case, they say the writ petition should have the averments in the stay petition to be treated as a complaint, lodge an FIR. How it is maintained? New jurisprudence you are developing.
My lord,
We are not on anything on the merits of the
it
matter.
is not at all expected from the state machineries to act in
But
this
then
regard, my
how
lord.
do we presume that? How do we presume
That's why
that?
you override that.
My lord, this is the only authority on the Prevention of Corruption Act, my lord.
By this writ petition, the petitioner seeks for a direction upon the Enforcement Directorate, the Central Bureau of Investigation, the Income Tax Department to conduct an independent inquiry against the third respondent in a time-bound manner. The petitioner has submitted representation to the authorities and has sought for the aforementioned prayer. Basically, the allegations are against the third respondent, which has a criminal flavor. In such circumstances, the petitioner cannot bypass the remedy provided under the Code of Criminal Procedure and straightaway file a writ petition as a public interest litigation and seek for a direction upon the authorities. Thus, we are of the view that the petitioner, if aggrieved by any action of the third respondent, should first exhaust the legal remedies available under the Code of Criminal Procedure and thereafter take the matter to the logical end. With the above observations, the writ petition is disposed of. Next.
Referral number 7.
My lord, I'm seeking an adjournment because the advocate on record for the petitioner, he has informed me that somebody has died in.
My lord, I am appearing for the state, my lord. It is a purely, my lord, the public interest. It is not a public interest, private interest litigation. Your lordship kindly come to paragraph 4 and 6 of the
But he
petition.
says that counsel somebody passed it.
I don't.
Not today.
On that score, no.
Not today.
Referral number 8.
Serial number 8, my lord, also, my lord, I'm seeking accommodation because my lord, service has not yet been effected to all the respondents, my lord.
ASG is appearing,
No,
DSG.
no, no, the difficulty is, it's a very serious issue. The scheme which was introduced by the government of India for Digital India and the other census programs. And that has been stopped. Now, there are several departments which have been made parties here. So, my lord, for taking necessary instruction, my lord, at least 2 weeks adjournment.
All right. In meantime, ASG can get instruction. Then you serve the other respondents.
But I have already served.
We are appearing for the state respondent also. State respondent, state
There are so many respondents. I have already sent, my lord, but it has not yet been effected. That is the reason I'm asking, my lord.
We have heard the learned advocate for the petitioner. Let the matter appear after service of notice on the respondents. The learned additional solicitor general appears for the Union of India, who may take necessary instruction in the meantime. List after service of notice.
Serial
Next.
number 9.
But I appear for the petition.
My lord, I appear, my lord.
Yes, sir.
This is pertains to Panchayat election matter, my lord. The service has been effected through email upon the respondents, my lord. That's the difficulty, my lord, since the election commission is not appearing, my lord. If your lordship kindly permits me for serving by hard copy, my lord. I have served it by, it has been served through email, my lord.
No. What is the prayer?
My lord, here, my lord, the petitioner, my lord, earlier filed a writ application, which is pending, challenging the Panchayat election. During the pendency, my lord, that in the main PIL, my lord, has been pleased to direct that the steps taken in the meantime shall abide by the result of the writ application. Here we have challenged, my lord, that notification whereby the respondents are taking steps for the reconstitution of the board, my lord, or Panchayat board. That is under challenge.
No, we can't grant.
It has become infectious.
We remember that you prayed for
Yes, my lord.
similar prayer you made. Don't multiply the matters because this is going to cause a lot of confusion. We can never ever hear those matters in 2023. Please take it from us. It's a very serious statement. If you keep on dragging the matters being listed on 22nd tomorrow.
24th, my lord. That other matter has been.
Other matters.
The contempt is 22nd.
22nd is tomorrow is the matter. Well, this writ petition pertains to the recently concluded Panchayat elections. It is not in dispute that the present writ petitioner had already filed an earlier writ petition. Therefore, it will be well open to the petitioner to canvass all grounds in the pending writ petition, which has been directed to be listed for hearing on 24/8/2023, and we find no reason to entertain this writ petition as it only result in multiplicity of proceedings. With the above observation, writ petition disposed of. Next.
Serial number.
Get.
Your lordship, I'm on the behalf of the petitioner, your lordship.
My lord, I beg to appear on behalf of private respondent number 9, my lord. We have just been served.
This is the affidavit of service, your honor.
Let us
Your
see the
lordship.
prayer. Cause for investigation complaint made to police station. All right, you pursue the matter.
Yes, your lordship.
Why writ petition? This can't be entertained, sir. This is no short circuit. You lodge some complaint with some station house officer. 3 days you will wait. You will file a PIL.
Your lordship, I have lodged this complaint on
No. You exhaust the remedies. which are
11th of
available
July,
under
your
law.
lordship.
This
And it's
petitioner, by
August,
way of this writ petition, seeks for direction upon the respondent police to cause an investigation on the complaint, which is alleged to have been made on 11/7/2023 before the Domjur police station,
your lordship.
and take action against the private respondents who are alleged to have been putting up some illegal construction. If the complaint has not been investigated or no desirable action has been taken, several remedies are provided under the Code of Criminal Procedure. And without exhausting those remedies, the petitioner cannot maintain a
Your lordship,
interest late petition for the aforementioned relief, aforestated relief. Therefore, we dispose of the writ petition, giving liberty to the petitioner to pursue his criminal complaint. And if no action has been taken, further action action has been taken by the said police. It will be open to the petitioner to invoke the other remedies available under the Code of Criminal Procedure.
Your
Next.
Your lordship, it's relating to the very public interest, very much public interest, your lordship.
Serial number 11.
Next.
Your lordship.
Much less, your lordships.
Yes. Serial 11.
My lord, item number 11, my lord. My lord, item number 11 and number 12 are
Formulation of a commission identifying illegal construction in ward number 78. Which is that municipality?
My lord, Kolkata Municipal Corporation. My lord, I'll narrate the facts and circumstances of the case, my lord. My lord, premises number.
Who have you been served? The respondent been served?
No, my lord.
List the matter after completion of service of notice on.
My lord, there is some urgency in the matter, my lord.
You serve notice. Next.
Serial number 12.
12 also same serve notice.
Serial number 13.
13, I appear for the petitioner, my lord. Lord, before I move my application, my lord, I was humbly beseeching your lordship for a leave, my lord. There is a error which is corrected, my lord. Lord, I have sought, my lord, that my representation, if lordship sees my prayer at page 18,
yes,
my lord, I have sought an order in the nature of mandamus, seeking, my lord, direction upon the concerned authorities, my lord, to, my lord, consider my representation, which is P2. But, my lord, that has erroneously gone down as P1. If my
No
lord,
problem. That you can correct.
Lord,
No,
but
in,
my lord,
in our petition, it says P2.
P2, but my lord, the annexure is P1.
P1. Okay.
That has been marked
You
as
can make
P1.
the correction.
Lordship will kindly grant leave to my learned advocate on that.
That we can do it.
But
What is
my
the
lord,
prayer sought for?
My lord, point is very short, but my lord, it strikes to the very
Identical relief, I think, was moved before the Honorable Supreme Court. And the Supreme Court dismissed the matter.
Subject to correction, my lord. Why the Honorable Supreme Court dismissed? Possibly there was no representation made, my lord. Lord,
please get that order.
Well, because possibly it's only one page order, my lord. I will try to. I will.
You
Lordship.
definitely.
No, no.
You know, trying. You have to get.
No, no. I'll get an order. And one more submission, my lord. Possibly, my lord, the service is not complete. That almost 36
So we will not say anything today. We'll just say list the matter after service. Leave granted to
correct the amendment.
List the matter after service of notice. Leave is granted to the learned advocate for the petitioner to effect a small correction in the prayer sought for in the petition.
My lord, not in the prayer, my lord, in the annexure, my lord, because the annexure P1 is to be
in the annexure to the state petition. Next.
Serial number 14.
I am for the applicant, my lord. This is a matter of ancient temple, my lord, situated in North Bengal, my lord. This is a temple called Jalpesh Temple. This is a Shiva Mandir, my lord. And since long, people. I'm late by Mr. Bhattacharya.
Yes, sir.
That this is an old temple. My lord, there is a custom that the people go there. So inside the particular Garbhagriha, which is known, my lord, for the purpose of pouring water into the limb of the Shiva. Now, my lord, there was a dispute with regard to pouring of water. Then, my lord, the matter came up for consideration before this honorable court. Now, my lord, I will be showing to an order, my lord, of a division bench of this court, which my lords may kindly peruse. It starts from, yes, my lord, I'm grateful to my lords. My lord, it starts from page 36. The relevant paragraph says at page 39.
39. Yes.
My lord, kindly see, my lord, this court, page 39, after considering the above fact, is of the view that the orders passed by the learned single judge in the writ petition can only be treated as public interest litigation, and the said writ petition is not maintainable before the honorable single judge, and thus we are of the view that the impugned orders dated such and such 5th of August 2022, 10th of August 2022, and 12th of August 2022 should be set aside. As the orders passed by the learned single judge are set aside, this court is of the view that in future, to avoid such circumstances, the Mandir committee, if any occasion arises for making any arrangement of any function in the said temple, should inform the state authorities, and the state authorities and the Mandir committee will sit together and frame guidelines for performing any function as desired by the Mandir committee and the local people of the said area. We further note that an individual cannot file a writ petition praying for the cause of the general public. And if individual is aggrieved and intends to pray any order for the public, it is to be dealt in a public interest litigation, which is to be filed before the Honorable Chief Justice of the Calcutta. Now, my lord, we have filed this public interest litigation for the purpose of, my lord, framing guidelines for performing any function, as my lord was noted by the Honorable Division
But
Bench.
there is page 41.
Yes, my
there
lord,
is some
page
pub-
41.
There's some public interest litigation.
Yes. Now, my lord, I tell your lordship may kindly consider that two orders have been passed. Now, on 19th of 7/2023, this order was passed by my lord, a division bench of this court, directing the block development officer to, my lord, consider the representation as a repetition as a representation and to take a decision after taking into account the order dated 5th of August 2022 in WPA 2106 of 2022. Now, this is relevant. Why I should draw it to the kind attention of the court? My lords may kindly come to page 29 for a second, because this order was set aside by the division bench, which my lords had already taken note of.
Okay.
Now, my lord, this is the order dated 5th of August 2022.
Yes.
This order has been set aside. Now, my lord, I find that certain, my lord, modalities have been indicated for the purpose of performing the particular, my lord, the pouring of water into the shiva. How it has to be done. Now, since these orders have been set aside, therefore, my lord, at this stage.
No, there is some order passed by the block development officer at page 42.
Page 42. My lord, I say, my lord, I kindly consider page 42. It is nothing but, my lord, the continuation of the proceeding of a division bench of this court. Kindly see, this is 19/7/2023. This order was passed in WPA 378 of 2023. Now, the block development officer, my lord, I stand the block development officer of Moinaguri, Jalpaiguri. Now, my lord, they, my lord, holds that for the purpose of, my lord, observing the mela and the my lord, pouring of water, there shall be installation of CCTV in the place where the water is poured. Now, that my lords will be pleased to find page 42, the order starts. Relevant portion is at page 43.
What is the guidelines you want?
Now, my lord, yes. Now, my lord, why it is so? My lord, I will be indicating to my lord that this pouring of water every day, my lord, 3 to 4 lakh people are coming. Old temple. Now, there is no, my lord, routine procedure. And my lord knows that wherever there will be a big mob, there will be, my lord, disturbance, and my lord, people will be shouting, people will be eager to go.
No, not that way.
Yes.
No, it is at least to my knowledge, in Tarakeshwar, lakhs and lakhs of people come.
The same.
No, please
Yes,
let me.
I'm sorry.
I
sorry.
visited there.
I'm sorry.
I've interacted with the Superintendent of Police. I've interacted with the district judge, the district magistrate, and the Superintendent of Police was so proud to say that even during that during the Shavan month and the other festival period, there has not been a single incident. There has not been a single incident. But there, unlike Kashi Vishwanath Temple at Varanasi, people are allowed to go in a line, pour water on the Shivling. In Kashi Vishwanath Temple, it is through a channel.
To a channel.
So therefore, in a writ petition, how to decide? You make your suggestions. Let the district magistrate, the committee people. Sir, if people, unless there is a mindset for the people and the devotees to fall in line, they will not. You may do thousands of thousands. I don't know whether you visited southern part of India, where lakhs and lakhs of, let us say, for one example, Tirumala. You know, have you been to
I went there once.
So there is a completely it is regulated. And they put you in a queue complexes, all facilities are there, and slowly you start moving. During some festival days, it takes as much as 72 hours in the queue complex for the devotees to reach the shrine. So therefore, the discipline should be with the devotee public. If you are indisciplined, all of us are indisciplined. What amount of regulation, what amount of police in, as far as I know, in this 2 years, I visited Tarakeshwar. Of course, it was in a lean period. Just then the festival, I forget the name of the festival. Huh?
Nearly 40 kilometers.
Yes.
They
Carry Kaveri.
Yes. Even from Calcutta.
People walk. In fact, sir, one of our group D staff, I was in court 16, he has walked 42 kilometers and he got prasad for all of us with the Kaveri on the shoulder.
Throughout the night, this.
Yes. And we call it in my state, we call it Kavadi, but it is much heavier than this.
Yes.
And they take water. Even where the place where I stay, 7 employees, they walked around 22 kilometers. They took water from Ganges. So therefore, it is all the mindset of the people. And we cannot be saying that you do this, don't put a barricade there, don't put a gate there, don't regulate. This law and order, regulation of the crowd should be best left to the committee. You give your inputs to the committee.
On a committee, I'm appearing. May I just want to point out one
You are for the committee.
You
take their suggestion.
I have already given a suggestion before that. My learned friend has referred an order of this.
No, we are not going to pass any order.
No, Lordship, kindly.
They have making some suggestion. You as a committee have an open mind. You cannot become higher than the deity themselves. No? At times it happens. The committee members think they are more supreme than the deity.
Lordship, I have not done it.
Then we will disband your committee.
Lordship, according to the wish of the devotees, my lord, I have already given a suggestion of the guideline to the.
We are not here to say, sir, we don't know. For speaking for myself, I don't know the topography.
My Lordship, kindly take page 44 for once of the writ application. For once. But the order was passed by the division bench of the Hon'ble Court, and thereafter I filed an application for modification of that order. Your Lordship will come to page 44.
Yes,
on
yes, we saw that
25th of July, the order was modified to the extent that the BDO was asked to consider the order passed in MAT 77. And my lord, in page 45, your Lordship will find a liberty was given to me to give up to my lord pray for the modification of the order of the SDO or the BDO. But I have already prayed for the modification of the order of the BDO, and some arrangement I have suggested to them that has not been considered.
And how are you elected, sir, or how are you selected?
Trust.
Trust.
But I have already given, kindly go through this proposal for once, and I have given a very detailed proposal to them.
It is. See,
create a balance.
Your proposal, the temple committee's proposal, the petitioner's proposal, everything the DM will consider.
I'm grateful to you, Lord. I'm grateful. That is the exactly my lord.
We can't do much.
Milord, 1 second. Milord,
You make a proposal.
No.
You make a proposal.
Milord, your lordship may kindly consider that the district magistrate, Milord, in my very respectful submission, subject to kind sanction of my lords, Milord, that they are not thinking of, Milord, at least some Milord criteria should be, as your lordship was indicating, because the persons who are visiting the temple, certainly, Milord, it is their greater responsibility is bestowed upon them to observe the law and procedure. But that is not in many cases. Your lordship will find, Milord, that this is not being observed because we want to visit the spot. It is a religious sentiment.
That is indiscipline.
Milord, it is a and that is
to go in a queue. They will not go in a queue.
Then
they will jump. Then this temple committee will give some recommendation, VIP pass. One fellow will come in front. This is indiscipline.
Yes,
you fall in line. You fall in line.
Milord, for that, Milord, your lordship may kindly consider, because Milord, the order
nothing can be done.
and Milord,
we will not pass any direction. We will give you liberty to give your suggestions, the temple committee suggestions. A meeting will be convened by the district magistrate with all the departmental people who are there. The block development officer, the superintendent of police, the other people, some volunteers, and they will take a decision. Sir, there are places in the country which there is much influx, sir. Much. You go to Puri. I can give umpteen instances. You visit temples, madam, please listen. I am addressing senior, I am addressing yourself also. You visit temples in state of Kerala. Have you been to state of Kerala? Nobody can jump the queue.
Nothing.
There have been big reports. The former chief minister of the state will go in a line.
In Padmanabha temple also.
Discipline lies here. Discipline lies here.
Yes, my lord,
Yes.
my lord, in Tarokeshwar or in any big temples, my lord, people can
So my
see, people can see, my lord, the deity from the
Tarakeshwar
distance.
you can't. Have you been to Tarakeshwar?
Yes, my lord, many times in Shravan Mash.
No, but you can't see it outside. You can see from only a small.
Yes, my
door.
lord, here we cannot, my lord.
So therefore,
The pipeline is 150 feet long, my lord, and this is zigzag type of pipeline. So we cannot see, we cannot darshan that Shivlinga, my
so
lord.
therefore, if you want to have a peaceful, pleasant darshan, you have to go choose the day and the month where there's not much crowd.
No, that is a 2 to 3 lakhs people in these particular days, and these are regulated only for those particular
3
days.
lakhs is nothing, sir.
Well, but the
40
entry
lakhs,
in
50 lakhs,
well,
you
what
can
it
speak.
appears,
In
what I
Puri,
instruction, well, the
every day around 10
entry is
lakhs people or 15 lakhs
a
people.
very,
Easy,
no,
sir.
not that.
Yes.
It is a very narrow entry. Therefore, we have to restrict for only these period as to this the guidelines that have been printed, nothing otherwise.
To make a balance between the security of the persons and their and the
Yes.
In
They have made all the
Tirumala,
arrangements. So lots of
15 lakh people take food on a daily basis.
Yes.
3 meals they provide. So you please visit that town. It is still kept spick and span. Of course, people, they come with that, what do you say, they're highly so spiritual, etc. They come trekking up the hill. They walk for almost 6.5 hours up the hill. There is another temple called, you don't know, Sabrimala.
Sabrimala, yes.
Have you been there?
Yes,
You need to. I've been there for 18 years, more than 18 years. It is through the jungle. People have to walk 45 kilometers. They will walk. It's complete pristine, thick jungle. And just before the festival time, because the temple doesn't open throughout the year. There are a time period within which it. So therefore, if there is a will, there is a way. You make constructive suggestion. We will call for a DM will call for a meeting. He will invite the petitioner. Petitioner is individual or organization.
Milord, they kindly see this particular individual.
No, does he not have any group or society?
Yes,
Mass petition is there.
petition has been submitted.
Pardon, sir?
Mass petition has been submitted.
Page 47.
No.
Page 47.
You do one thing. You choose 3 people among your this mass petition people. Let them give suggestions. It should not be. It should be specific suggestions. This can be done.
Yes.
That can be done. Then you also your committee suggestion is also there.
I will.
Then the
Yes,
DM
yes,
will convene a
yes,
meeting.
yes.
Invite 3 of them.
Yes,
Huh?
that will do.
You will do. Definitely, it can be regulated, sir.
I have received n number of
We are trying to regulate parking in the High Court.
Milord, that will become again another
It
very
is next to
Milord,
impossible now.
Milord, I say, Milord,
On
with the
division.
greatest of respect,
Spending so much of man hours on that.
when coming to court, the first thing, Milord, we have to do is where to park the car. And that starts from, Milord, the Khudiram.
Even before that,
Yes.
right from the stadium, but right from Maidan itself.
Yes.
By this public interest litigation, the petitioner, on his behalf and on behalf of the other people, has sought for appropriate directions upon the respondents to frame a permanent guideline for the devotees and pilgrims of Jalpesh Temple in the matter of their pouring and offering water to the deity by entering into the Graha upon consultation with the temple committee, who are the respondents 7 to 9, and upon holding a public consultation / public hearing with the local people. Though there were earlier writ petitions filed before this court, one before the learned single bench and the other before the before the Hon'ble division bench as a public interest litigation, we feel that those orders and directions need not be referred to as the same have worked itself out, as it resulted in an order passed by the block development officer, Mayanaguri, Jalpaiguri, dated 1/6/2023. Subsequently, there was a modification of the order passed by the division bench, and the block development officer has passed another order on 28/7/2023. The petitioner on his behalf and on behalf of others have submitted a joint representation on 24/7/2023. The sum and substance of the representation is to formulate a proper procedure or guidelines to enable the devotees and pilgrims to offer their prayers in the said temple, which includes pouring and offering water to the deity. The private respondents are the temple committee, who have also submitted their representation on 27/7/2023 for praying for modification of the order passed by the block development officer dated 21/7/2023. So far as regulating the manner of worship in a public temple or in a temple or any place of worship has to be best left to the district administration to take care of the same. There are several instances in the state of West Bengal where the district administration has been proactive and has been regulating the influx of the pilgrims in various places of worship as well as places of public importance. Therefore, the petitioner and his co-signatories in the representation should bestow confidence in the district administration that they will do the best to ensure that the devotees offer their prayers in an appropriate manner. It goes without saying that the district administration, considering various issues, including the large influx of pilgrims on particular season, are entitled to formulate procedure to regulate the crowd and to maintain the law and order in the area, and also ensure the health and hygiene of the pilgrims who visit the particular place of worship. Therefore, this court is of the view that the matter has to be entrusted with the district administration to formulate an appropriate procedure, and for which purpose the district magistrate shall do the needful in the matter by forming a committee consisting of the superintendent of police and other officials, and also a representative from the temple management committee, and 3 representatives from the petitioner, from the persons who have submitted the joint representation dated 24/7/2023. We direct the petitioner and others to submit a proposal as to how best the pilgrims can be permitted to offer their worship to the particular deity, and the suggestions to be given by the petitioner and others should be specific and not vague. In the meeting that shall be convened by the district magistrate, the suggestions by the temple committee and the suggestions by the petitioner and others shall be placed, and the decision shall be taken by the district magistrate and the officials, bearing in mind the convenience of the worshipping public. A decision in this regard be taken as expeditiously as possible, preferably within a period of 3 weeks from the date on which the suggestions are placed before the district.
I'm grateful. My lord, only thing, my lord, that if they feel district administration that they will be formulating guidelines. It will be open for them to frame the guidelines. Kindly indicate that, my lord.
The district magistrate, upon considering all the factors,
Yes, I'm
shall
grateful to my lord.
formulate the guidelines and issue necessary direction to the field formations to strictly implement those guidelines.
I'm extremely grateful.
Next,
Serial number 15.
Yeah,
Lord, I have to
affidavit of service. Affidavit of service.
For the state respondents, my lord.
My lord, I am appearing for union of interest.
Petitioner is a trust and Lord represented by one of the petitioner, Lord. They have, Lord, what has happened in this case, Lord, the central government, Lord, issued a Lord notification for appointment of Lord constables in various departments of the Lord central government. Now, Lord, the allotments were made in respect of Lord various states. Lord, the quantum and Lord, your lordship would kindly take Lord page 23. Lord, for to be eligible, Lord, from this state, Lord, a domicile certificate is required. Now, Lord, it has come to notice that the domicile certificate has been forged and Lord used for the purpose of Lord taking participation.
all domicile certificates,
Lord,
forged.
not all, but there are many, Lord, which Lord we could get, Lord.
And you have given instances.
Lord, I have given 4 instances where, Lord, the domicile certificate has been forged and, Lord, used for the purpose of, Lord, employment. Now, your lordship would, for that reason, Lord, there are specific complaints. Lord, what I beseech subject lordship kind sanction, Lord, there are 90,000 persons, Lord. Yesterday, Lord, a list has been published for the post of, Lord.
See, basically, if it is a service matter, PAL is not
Lord,
maintained.
not, Lord,
But your allegation is fraud has been played.
my Lord, that is my contention.
But then, if fraud has been played, should not the persons who have played fraud be implemented?
Lord, it's not, Lord, one fraud. Lord, this is the domicile. Another issue is,
And who's the petitioner?
Lord, the petitioner, Lord, is an individual representing a trust, Lord. Lord, I've explained that paragraph 1. Now, Lord, there is more. Lord, the domicile certificate, whatever is being issued, the department is not, Lord, scrutinizing it. It is only, Lord, they are comparing with the original.
No, see, normally, caste certificate is issued.
My Lord,
Based on that caste certificate, appointment is issued.
my Lord.
Thereafter, a complaint is lodged.
Well.
They immediately refer the certificate for verification. In certain other states, the moment you claim reservation based on some certificate, they say you are provisionally selected, subject to verification of the authenticity. Immediately it is sent to the other department. The other department gives their reply. Based on that, they will take action. If it is reported that the certificate is
Forged
or some other means have been adopted, then there is no.
Here there is no scope. Only, Lord, comparing. That is what I was.
No, correct. In all recruitments, see that exercise, let us assume 1 lakh people apply. You want a pre-verification to be done is next to impossible.
I'm not even.
Post-selection, obviously fraud vitiates every
Everything.
solemn act.
No, that's
So
the
this large scale, like 90,000.
Lord, what I beseech subject lordship kind sanction, Lord, to interfere and, Lord, let the central government as well as, Lord, the state government take a steps in respect of, Lord, this using of forged documents. That is the reason, Lord, I have given instances, Lord, of 4.
Once you allege forge and fraud or forgery, the concerned person who has committed the crime needs to be.
Now, Lord, in the garb of this, Lord, there are many who are not scored. They are free and they are using it, and, Lord, they are getting.
You give a representation, probably we can direct the whichever is the recruiting agency.
Lord, we have, there are 2 FIR registered in respect of, Lord, the similar kind of, Lord, offences. But it is difficult, Lord, to point out, Lord, who else have, Lord, forged the domicile certificate. Now, Lord, I was on a different note, Lord. The domicile certificate, Lord, has a process. Lord, the state government has made a website, and, Lord, there somebody goes and fills up the forms, and thereafter, Lord, after verification, that thing is done. But here, Lord, it is not. It is being collected from, Lord, the office, and, Lord, it is being
Where is your representation?
Lord,
where you alleged a large scale fraud?
we have not, Lord, given any representation, Lord. We straightway want to, Lord, take your lordship, Lord.
That can't be. You give a representation to the selection committee. The selection committee will first consider. First consider.
And
This short circuit,
blood, it's not blood, since blood, it is involved blood various things.
maybe you point out one instance. It is for the selection committee. Who are you, sir?
On RAM for representing the state for respond number 11 and 12, the police authority, the concerned police authority, they have already commenced the investigation on the basis of the report.
This 2 or 3 FIRs, sir. The larger issues with the central government. with
And
the
we have,
staff
my
section.
lord, may I respectfully make one submission as regards to the private respondents whom the petitioner have made a party. Some of them has already been declared unfit. We have conducted a
Already.
Now, since we have raised a voice,
verification
that is the reason
process.
they have
Good, good,
disqualified.
It's all right. By this public
My lord,
interest
with your lordship
litigation, the
kind
peti-
leave, my lord,
the
may I just
petitioner-
indicate one thing, my lord?
Yes.
My lord, this issue, my lord, is no more res integra. There was a writ application filed by a whistleblower, one Mr. Vishnu Chaudhary. Now, my lord, the CBI, the CID, the army, the central forces, all were parties. But the CID had taken a stand that since it comes to, it pertains to national interest, we will not stand in the way. There was a direction for conducting preliminary inquiry by both CID and CBI. Both of us, my lord, submitted reports. Now, on the basis of the orders passed by the Honorable Court, my lord, the CBI is already investigating, my lord, into this issue.
What is that writ petition number?
My lord, I'll supply the writ petition number. The name of the petitioner is
And
Vishnu Chaudhary.
he will give this, some of the documents he has collected. Based on that, you take cognizance of that. Let the staff.
We
selection-
have already, my lord, conducted preliminary inquiry, submitted a
But
report.
then you should
Lord,
use a.
Lord, I have a copy of the order, Lord. I have a copy of the order since
Disclosed it then.
You should have enclosed it in.
Lord, we came subsequently after filing, Lord, we came to know.
Issued a
The day before
disclaimer or
yesterday, I
you
came
should
to know.
issue a public notice saying that inquiry is on, people are requested to cooperate, etc. So that by this.
May I
public
just
interest
add one
litigation-
subject to lordship kind sanction, Lord? Can
In
you,
fact,
lordship,
my
add
lord,
one?
we are already in the process of
The
verification. of some of
appointment
the
is
candidates.
subject to, Lord, the verification of the domicile.
By this public interest lit petition, the petitioner seeks for a very large and a widely couched relief by directing for directing the respondents to stop the entire recruitment process, which has been commenced in the year 2022 by conducting an open competitive examination for recruitment to the post of constable within bracket general duty in the various central forces. And insofar as it relates to the personnel who were recruited and posted in the state of West Bengal. The main issue based on which the writ petition has been filed is that domicile certificate is issued by the state of West Bengal, which are invariably forged and fabricated documents or certificates which have been issued without proper verification by the state authorities. In this regard, criminal complaint has also been lodged and FIR has been registered in certain cases. The Learned Government Council appearing for the respondent police submits that the case which has been registered by the Haringatta police
Horingata.
Police Station.
police in case number 309 of 2023 has been and in Madhyagram police station in case number 448 of 2023 have already been taken on file. FIR has been registered and verification is going on. The investigation is in progress. We find that though the petitioner has made very serious allegations of fraud and forgery being committed, it appears that the petitioner has not brought to these facts to the notice of the appropriate authorities by way of a representation before filing this writ petition. The learned Deputy Solicitor General appearing for the
But I'm not a party, my lord. I thought, my lord, it is my duty to inform.
the learned Deputy Solicitor General had intervened in the matter and submitted that a learned single bench of this court in WPA 126/25 of 2023 dealt with a similar issue and an order was passed on 2/8/2023 and pursuant to the directions issued therein, the Central Board of Investigation within bracket CBI has registered a case and has commenced investigation into the recruitment in the Central Armed Police Forces, which are alleged to have been police forces, wherein there was an allegation that certain candidates have participated in the selection process by producing forged and fake documents. Considering the wide ramification of the matter, and also taking note of the fact that CBI has already commenced investigation, and also taking note of the submission of the learned Central Government Standing Council, who on instruction would submit that already verification is being done by the recruiting agency, and in certain cases, recruitments have also been cancelled. In the light of the above, we direct the petitioner to submit a comprehensive representation to the fifth respondent, namely the Staff Selection Commission, Government of India, pointing out specific instances and also enclosing documents in support of their contentions. If such representation is received, the Staff Selection Commission shall consider the same and include those take necessary steps for verification of the issues which have been pointed out by the writ petitioner. The issues that will be pointed out by the writ petitioner in the representation which has been directed to be submitted. In this regard, if any information is required from the sixth respondent, but which is the department which gives the certificate? Secretary?
The DM and the SDO. District Magistrate and the SDO.
SDO is the competent authority.
In this regard, if any information / verification is required from the state of West Bengal, the Staff Selection Commission or any other authority of the central government shall call for such information. And if such information is called for, the secretary, principal secretary, or Department of Home Affairs, State of West Bengal, shall call for the necessary information from the respective district magistrates and submit the same to the to the Staff Selection Commission or any other central authority without loss of time. With the above observation, the writ petition.
But your lordship has said respondent number 5, it would be respondent number 2 and 3 because the 2 is the chairman Staff Selection Commission. Your lordship has said 5 is the different Director General of Police.
So while Staff Selection Commission has nothing to do, very little scope with regards to the recruitment process. Only the computer-based examination is taken by the Staff Selection Commission. The physical standard test and the medical examination all were taken by the concerned nodal forces.
So, or we have said Staff Selection Commission or any other authority of the central government, namely the recruiting agency of the respective central armed
forces. Deeply blessed.
Next.
May I also beseech your lordship, since the CBI is investigating pursuant to orders being passed by the Honorable Court, but the state police may also be directed whenever they are in receipt of such information to forward it to the CBI. Otherwise, there will be multiplicity.
In order to ensure that the investigation done by the CBI is proceeded in an appropriate manner, the state police shall share information received by them wherever complaints are lodged regarding the fake and forged domicile certificate to the CBI, Kolkata unit for
CBI ACB Kolkata.
ACB Kolkata. Next.
Grateful.
I am grateful to you.
Serial number 16.
Lordship, I appeared in person, your lordship.
I have believe on one matter relating to Jadavpur University, my lord.
Yes.
Lordship, affidavit.
We have already read your writ petition in the newspaper.
Newspaper.
All
This-
newspapers. We need not go through the other.
Exactly, your lordship.
I think affidavit is given to the press before it is being filed in the department.
But if it could be not possible, not if my learned friend could serve a copy of the petition on me.
Including the name of the petitioner, everything we know.
Include all the media, friends of media present over here, your lordship.
No, it is there from Saturday onwards. Saying that we will hear. Only thing it didn't say the time. We will hear it at 11:30 or 11:45.
Because the matter is so high, your lordship, right now, probably.
Yes.
Lordship.
Mandamus directing the authorities. Oh, not served. UGC not served. But
Lordship,
there is a standing counsel for UGC.
Yes. Lordship, this is the last.
You could have informed the standing counsel for UGC.
Yes, Lordship, we have
To regularly appear.
Mr. Anil Gupta.
Lordship, I have sent them through email number 1 and I have sent it through the speed post.
You are appearing in person and he is a brother member of the bar. Nothing prevented you from calling up him in the morning.
Lordship,
You could have met him in the corridor. Sir, this matter is coming up.
Lordship,
It is not a personal interest litigation.
No, not at all.
Next is it's not a political interest litigation. Never. So therefore,
Lordship, I was not aware of that,
you
Lordship.
please serve notice.
My lord, let the matter be taken up tomorrow, my lord, along with the matter which I believe was.
Yes. First serve them, sir.
But I am serving.
University is there. Between today and Monday, nothing will happen. Or today and Wednesday, nothing will happen.
Within 3, I said, sir. Within 3.
You serve.
If my learned friend serve on me, there is
yes.
none.
Please serve.
At the university, it will take. some
Lordship,
time.
respondent number 1, 2, 3, 4, I have served your lordship.
3 also you serve.
Yes.
Similarly, you
No,
also serve.
not 3. Except 3, probably
3
it was not
will,
done.
direct you to serve on the standing house.
Gratefully.
Instead of selling it to Delhi, you can give it. The learned, the petitioner appearing in person is directed to serve notice on the learned standing counsel for the third respondent from a University Grants Commission. The learned, the petitioner shall also serve the copy of the stay petition, copy of the writ petition on the learned advocates appearing for the respondents within 2 days from date.
My lord, I appear for the state, my lord. I am here for the state.
Yes, sir. List the matter. When shall we list it, sir? List the matter under the same caption on 28th August. The for him also leave granted to you. Leave is granted to you. You also serve notice.
My lord,
For matter
there are some urgency, my lord. May they be
matter will
taken up
come up
tomorrow,
on
my lord.
28th or it will never come. We'll release it.
Lord, I have also filed another petition.
You
Pursuant to that.
file. All of you file.
Serial number 17.
My lord, I am 17.
My lord, I appear for the state.
Really, I am praying, my lord, the relief against the university administration, and I will be making a prayer to your lordships, my lord, to take an overall view, holistic view over this matter, and my lord, at the end of these things, which I have considered in my own way, my lord, although there are judgments, there are guides, but some arena is there which has not yet been touched.
But here senior is not appearing for state.
Pardon?
Senior is not
No. I am for the petitioners.
because the entire battalion is state battalion.
These are my juniors, my lord. We are, my lord, I tell you.
This is all state battalion.
Maybe. My lord,
And the other two pillars of state, he's learned
Lord, can I-
advocate general is there.
my lord,
Our
can,
learned government
can I
pleader is
take
there.
your lordships 1 minute time just in 9?
And Mr. Mazumdar was appearing for the state in the.
No, for the,
the
not
university.
for the university.
For the university.
Mr. Mujumdar has gone to that side now. I am in this side. My lord, just I take your
appear for a
lordships
state aided
before
university.
I
They
just
put it in
comment,
this way.
since your lordships have said to me, my lord, I tell your lordships very interesting thing. In 1984, one of my friend, he has expired now, Mr. Chandranath Mukherjee, went to take me at Patna for doing one matter.
At the end of the day, he told me, I will take you to one gentleman. He didn't disclose me the name. But I went with him at the 5 or 5:30. It's an old Jamindari house. One gentleman was sitting in the wooden cart, in a simple in this manner, sitting and fatwa and it's just before that he didn't tell his name, identity. When I entered in his room, he told me he is Justice Ellen Sharma, who became the Chief Justice of India later on. I touched his feet. He said to me first one thing. Have you gone to station? Yes. Well, have you seen any vegetable train? Yes. Well, have you seen the compartments? Yes. Have you entered into the compartments? Yes. Have you used the vegetable train going from one compartment to another compartment? Yes. When I don't know why he said to me on that day in 1984, and I keep it in my mind, I proceed in my life in that way. When you will remain in a compartment, you think about that compartment only. Don't think about other compartments. When you will go to other compartments, you think about that compartment. But when you will see the whole train, you think about the whole train. Lord, my life is this, Lord, that I am from one compartment to another compartment. Therefore, standing in one compartment.
That is the privilege of a designated senior advocate. You are not confined to this side or
That's it. That's exactly. But Lord, my entire purpose, let me tell you, Lord, I will begin with this. Lord, my entire purpose of, don't take it in other way. My entire purpose is to bring extremely standard position in an educational institution like Jadavpur University, which have gone down like anything. Malad, remember one thing, Malad. I am on a very different points. Malad, even the remote places, village, the meritorious student of this state, not only this state, also other states, they are having a dream to come down to Jadavpur University and to be admitted. And who these students belongs to a middle class or rather lower middle class family. The parents are having extreme dream that if my student, my boy, is admitted in an university like a Jadavpur University, he will be one day a scholar, he will come up with a high educational qualification and he will. This is the idea, my lord. Freshers are coming. For long years, the freshers are rigged. Rigging and ragging is so for me it's
that's because you've been appearing too many election matters.
Ragged. Now, yesterday's fresher is becoming today's in the middle. Tomorrow he is becoming Dada. Tomorrow he is taking the entire charge, becoming Dada. I mean, you know, in the Dada in the Para, in a neighborhood is a real mafias, which is said. Yesterday's fresher is becoming today's in the middle stage. Tomorrow he is going to the top, and sufferings which he had made, the freshers, he is carrying on since the university is not taking any steps against anyone and not pointing out making not any complaint to anybody. It is the job of the university to vigil everything. This ragging is continuing for decades together. And university is completely silent over the matter. Now, therefore, kindly appreciate this. A fresher who is today is being subject to ragging. What he is getting, criminality mind is being grown up in his mind. And today, who is a fresher, tomorrow, he says that when I am becoming a senior student, I will take the recourse of the ragging. This is the Milord, ragging in I don't know, Milord, whether your lordships have spent your lordships days in any hostel or not. But yes, and Milord, it was in our days, it was something different. When you were entering, come one day introduction. Seniors calling, sing Rabindra Sangeet, recite, go for swimming, helping. I was in the hostel in class 9. Because of the seniors, I learned how to swim. Pushed it in the. This is, but today's it has becoming inhuman things. Because of the incidents occurred today, it has surfaced. In 2016, it was also there in the Jadavpur University itself. Jadavpur University itself, it was there. Now, one person expired. He went cry for few days. Then everyone is silent. Today in 2023, it is there. Why it is ragged and other things below the percentage, that's the subject matter of criminal investigation. I am not going to speak any single word for that. Now, kindly see, I just tell your lordships, giving a very short description of the university for your lordships information, so that your lordships can understand that. Kindly come to page 8. First, I tell you that this is one of the university. It is now 4th or 5th stand in the India. Within India is the 5th, 4th in India. And if I am right, I have read few years back, 1 year, 2 years back, in some of the report, it was showing 30 or 35, the serial number 30 and 35 in the worlds. This university, kindly see now. Now, paragraph 8, the 68-year-old university has 36 departments. Come to paragraph 8. 36 departments, 21 interdisciplinary schools, and 40 centers of study, which in total offers 39 undergraduate courses, 57 postgraduate courses, 14 MPhil courses, and 14 PhD courses. The university is spread over 3 sprawling campuses. The main campus having an area of 67.66 acres, including 7.6 acres of new campus. The second campus at Salt Lake having area of 20.3 acres, and the erstwhile Neil campus 7.6 acres. The university has 4 auditoriums. This is I have given the total 9 canteen, huge playground, gymnasium, indoor and outdoor stadium, 9 boys hostel with around 1,190 boarders, and 4 girls hostel with around 485 boarders. The count of enrolled students at the university for 2023 is around 4,268. In short, not only being one of the finer tier 1 institution of the country, as also of the state, is not only holding higher ranking, overall 4th in India as per NIRF, so and so. It's not very required. Now, let's kindly see the guidelines which were there earlier. I have spoken about these guidelines, policy regulation, UGC guidelines. I will show it later on. But I am just pointing out the facts first of all. But kindly come to paragraph, page 11, 8A.
Yes.
8A. On 9th August 2023 at around 11:30 p.m., an underage student of BA in Bengali, honors namely Shopnodip Kundu of Nodia, was found naked in pool of blood on the ground outside the A2 University hostel. He was rushed to the nearest KPC Medical College and hostel, where they said Shopnodip was declared dead around 4:30 am of 10th August 2023. After the horrific, unfortunate, and ill-fated incident, the family members of the Shopnodip were informed and they are rushed to the hospital, but only to find their son dead. Look, kindly mark it here. Just one thing has not been written. The point is, university did not lodge any FIR to the police on that day. Students who took them there, they didn't. Who did it? The parents who came from the district of Nodia, they lost the complaint. Number 1. Subsequently, the media reported of that few arrests have been made, among others, Saurabh Chaudhary, who is one of the main accused and whose leadership shouts once. But one of the important things, it has been recorded, written somewhere in sub. There I am. When the Jadavpur, the police came to learn something from that something has been happened. When they went to this campus hostel, the gates were locked. Police were not allowed to enter. Entire police force were stopped there. Nobody was entered. I will show the photographs. It is completely dark. And every day it is dark. I will show the photographs. Then the police received an information that one taxi was going on the hospital? KPC hospital. Then the police went there to the KPC hospital and found that this has been happened. And then in the meantime, they came, the FIR was lost and the police had been carrying the. Why I am pointing out, why these students of the university and hostels have become so much violent, have become so much indisciplined. Why they are demanding so much that at no point of time, no one, even I am university administration, the vice chancellor, etc., they are not allowed to function even. I will come one by one. The shocking incidents, shocking things are going on in the university itself, whole campus, not only hostel. Therefore, I am not restricting, I am not so far the ragging is concerned. My whole thing is, on the other day I mentioned, broader. Now, kindly come to see that in that paragraph, one of the main, under whose leadership the directions upon the had been subject to vigorous ragging and who is believed to have been present in along with some other students. Where
is the act?
University Act I have brought.
Which by which the university was constituted?
Yes, I have brought University Act. I have University Jadavpur University Act. This is 1981 Act. University Act. Your lordships will not find anything what in the act what has been said. In fact, anti-ragging guidelines was first laid down by this High Court in 1994. I will show to you. And the act of anti-ragging came into the West Bengal in 2000. Correct. I'm asked. 2016. University Act. আমাদের কপি আছে একটা পড়ার জন্য বার কর দরকার হলে বার করি
In terms of section 46 of the Jadavpur University Act 1981, this deals with ordinances. Subject to the provisions of this act and the statute, ordinances may be made to provide for all or any of the following matters. What will be relevant is clause C. The conditions of residence and rules of discipline of students of the university, including students of the colleges and as institutions affiliated to or recognized by it, and the levy of fees for residence in halls. Then the next will be clause E. Rules for recognition of, recognition of libraries, laboratories, museums, hostels and institutions for study, research and residence other than those established, maintained and managed by the university. Then K, rules for registration of students. So are there any statutes or ordinances framed regulating the rules for residence in a hostel? What are the terms and conditions? Under normal circumstances, from what we all know, that there will be several hostel blocks, boys hostel, girls hostel, and a fresher will be allotted in a particular block. And upon completion of the first year of study, the fresher has to vacate the hostel during the vacation period, during which 15 days or 1 month maintenance will be done. And upon reopening, when he progresses to the second year, let us say humanities, it's a 3-year course. Second year will be in another block. Third year will be another block. A PG student will be in another block. So this is how it is regulated. So first we need to see as to what are the ordinances or statutes or rules or regulations regulating the accommodation in hostel.
May I just?
That the university will answer.
University will, but since your lordship is there, this is exactly 2009 Supreme Court has said this. What your lordships are saying this. That, and later on the UGC guidelines have also come. That the first year in the one hostel, in the night, no one will be allowed any senior.
No, that we will see the rules, sir. Because
I will read the guidelines itself.
No, it is not a lease, it is not a license. It is only a license to occupy.
Correct.
So therefore, the university can regulate the timings.
Correct.
Can regulate what activities can be done, cannot be done. Can also regulate who can come in, who can go out. And it can also regulate as to who can visit a hosteler at what time. So let us see the university rules, whether the rules have been implemented, etc. So because you have given some photographs, campus has not been properly lit. The prayers, we have seen the prayers, various prayers.
Lots of have seen that.
And some of them are seeking implementation of the UGC guidelines, for which already we have ordered notice. 28th, the matter is going to come. UGC, we need to hear UGC on that. We will see. Let the university respond.
If your lordships permit me, if your lordships just permit me, I have served the copies of that supplementary affidavit I have filed. If your lordships just permit me to file it.
What is that supplementary? But the writ petition was filed day before yesterday. Why a supplementary?
Thereafter, no. Why? Because in the meantime, an order has been passed. After filing of this writ petition, an order has been passed by the university. Saying that from 8 p.m. to if anybody wants to enter, then they have to take permission, etc. Outside have to take permission. My submission is this: 2009 Supreme Court judgment has very clearly said, and the UGC guidelines have clearly said, no one will be allowed to the freshers hostel after 8 p.m. or 9 p.m. Why this today it is coming with this circular, which is totally contrary.
All right. Now we are discussing an issue in the absence of the students.
Yes.
Your entire grievance is against the students who you are, in your opinion, you say they become so violent and they graduate to a position of a dada on graduating from the university, whether they get a degree or they become a. So in the absence of the students, they need to be heard in the matter. Because under the Act, Students' Union has been defined.
Yes.
If you see section 2, subsection 18.
Please.
Students' union means A, in relation to the university students' union constituted in the manner prescribed, and B, in relation to affiliated college, the students' union constituted in the manner prescribed. We are only concerned with the university campus, not with the affiliate college.
No, not
How
really.
many colleges?
Only
are-
one affiliated college.
Ah,
Not affiliated.
So it is only the, so there is a students' union means in relation to the university, students' union constituted in the manner prescribed. What is the manner prescribed? We need to say whether separate regulations or rules have been framed for the purpose of, because this also I saw somewhere some elections, etc. The students need to be heard in the matter.
But I don't mind. Let them be
If there
heard.
is a
Your lordship.
students' union,
There are three or
recognized
four.
union,
Very
That's
nice.
here.
and we implead, you can implead them.
Yes, yes.
Let them be served.
Let them. But my lord, can I just 2 or 3?
Not required. We'll go stay overnight. Nothing can change.
Nothing can be done.
Nothing can change overnight.
My lord,
But
one
one thing,
I am
of
one urgent thing has come up. One urgent that your lordship kindly just consider this. What has happened, my lord? CCTV camera was installed in 2012. 53 hours, Vice Chancellor was Giraud. Then he had to resign, the Vice Chancellor. Then another Vice Chancellor came. The then Vice Chancellor wanted to continue with it. He had to resign. In 2016, another Vice Chancellor came. And my lord, the interesting caption was, first day, first show, remove all CCTV cameras. No CCTV cameras are allowed to be installed.
and why the Vice Chancellor took such a decision?
I don't know. He wanted to be very friendly, must be very friendly, student-friendly Vice Chancellor. 2 Vice Chancellors get out for 53 hours, had to resign. Second three Vice Chancellor had to resign. But 2016, the Vice Chancellor who came, first day, first show, that's the big caption. First day, first show, removed. And see, from 2016, one student, my lord, he died because of the ragging. December. Urgency is this, my lord, today. My lord, if your lordship has seen, since your lordship has seen my petitions, your lordship has made
No,
this
we'll
observation.
await for the response of the
I
university.
have annexed the photographs.
We saw
That from the evening, see this.
No, we saw the photographs. According to you, you have given this GPS map camera also.
Yes, yes. That's
from page 63.
From page
Everything is very dark.
very dark. No light, no one. No one should be allowed to, no use. Now, lordships kindly consider now at this moment whether it is required or not, and for that reason, the students' union have to be heard or not.
Yes, they need to be heard because the allegations is against the students who are pursuing the studies. But on behalf of the state, AG is appearing. What AG would like to say? Sir, please unmute, sir. Please unmute. Yes.
My lord, sadly, my lord, ragging, my lord, has, my lord, become, my lord, endemic to, my lord, institutions, particularly of the engineering field. My lord, and it's, my lord, pan-India. It's not just, my lord, in this state. It's gone, my lord, beyond, my lord, what one can call, my lord, social interaction of, my lord, seniors introducing themselves to, my lord, juniors, and juniors introducing themselves to seniors. Now, my lord, I don't think, my lord, it's been, my lord, a situation where, my lord, it is not been known that there have been excesses. And my lord, excesses have happened, my lord, all over, my lord, the premier institutions in this country. And I think now, my lord, with all, my lord, the students' freedom, my lord, which we enjoyed, which your lordships, I'm sure, would have enjoyed, my lord, when going through, my lord, getting a degree, my lord, if, my lord, we find, my lord, that the students themselves, my lord, are not able to regulate and see, my lord, that there is peace and harmony, my lord, there have to be, my lord, harsh measures undertaken. In fact, my lord, your lordships will kindly examine, as it fell from your lordships today, are there statutes, are there ordinances, are there rules prescribed with regard to giving, my lord, recognition, my lord, to students' unions, my lord, with regard to, my lord, occupation of hostels, and, my lord, the manner and method of occupation. My lord, these are, my lord, very important, because if they are not there, they, with the autonomy that the universities, my lord, enjoy, they should, my lord, come into force immediately. And second, my lord, this is, my lord, a situation, my lord, which has been noticed by our High Court before. It has been noticed, my lord, by the Kerala High Court, my lord, in, my lord, a very illuminating judgment. And also, my lord, by the Raghavan Committee, my lord, which was set up, and, my lord, whose, my lord, observations were, my lord, directed to be implemented by the Supreme Court, other than, my lord, UGC regulations. Because at the end of the day, my lord, my lord, experiences, my lord, which are, my lord, acquired, my lord, in such an environment can either make the person or scar the person for life. My lord, it's really, my lord, something we should look at with all seriousness. My lord, my respectful submission to your lordships would be, my lord, have, my lord, all the stakeholders before your lordships and kindly see, my lord, that whatever your lordships direct, my lord, is implemented in every institution, my lord, in this state.
Now, Mr. Bandyopadhyay submitted, when that unfortunate incident occurred, the police were not able to enter the university.
Yes, my lord, we have, my lord, lodged a case on that basis, my lord, that we were prevented access.
And who prevented them? Whether the
My lord,
gates...
there were, my lord, my lord, I have named, my lord, I have, my lord, the students, my lord, one of them was Joydeep Ghosh. My lord, I have, my lord, a report to that effect. And, my lord, this is, my lord, police station case number 152, my lord, of 13th of August in Jadavpur, under 186 and 353.
Is it a fact, Mr. Mazmundar, that police couldn't enter the...
It's reported, no, it's reported. It should not have been, but it's reported. But I don't know, it's only 5 or 6 houses away from the place, the main hostel. Probably 100 years away from the police station.
Whatever issues have been pointed out, has it affected the general public in any manner?
Not after the incident, not day before yesterday also, there had been large-scale demonstration that we had tried to relocate the fresher temporarily in the university campus. Now, not the in-campus students, these students would be put in a different block for the time being so that they are not traumatized, they are not, the situation does not aggravate. They went on a hunger strike for 24 hours, not allowing us to induct those students in the in-campus hostel.
Who went on hunger strike?
Not the residing students of the boys hostel, which is within the campus.
Okay.
So they felt that we are being inconvenienced by reason of the temporary induction of the freshers in the from the main hostel to the boys hostel.
No, boys hostel is senior hostel, is it?
Boys hostel is one which is outside the campus, just 5 or 6 houses away from the Jadavpur police station.
All right.
And the main hostel, the boys hostel is within the university campus.
Very good.
I'm not, for the time being, since this incident occurred and there was our environment of trauma in the minds of the young students, the freshers, we wanted to relocate them temporarily in the in-campus hostel, the boys hostel. Now, the residing...
But see, inconvenience may be caused if suppose there are already 4 students in a room.
No, in a different block.
The block is empty.
We wanted to accommodate them temporarily. Now, these students went on a hunger strike and not the registrar and some other administrative officers were get out. Not there had been large scale demonstration by political parties on the road and inside the campus. Not for the time being, we request through the petitioner.
No. You can't convert this into a political platform.
This
please.
was not, it's in the air every day.
No. They may give statements, but not entering the university, etc. That
Just outside the road,
that will be
there
our
was
appeal. No
large-scale
political
demonstration.
party. You shouldn't make.
Public inconvenience was caused, as I read from the newspaper.
Yes, he's correct. Public inconvenience is caused.
But
Some of
Traffic
tremendous
had to be diverted also, my lord.
from inside.
Traffic had to be diverted.
From Jadavpur to, no one can come to Gorihat or Gorihat to Jadavpur.
Today,
During this, but this is not the incident of 2023 today.
No, that the police will regulate. If it is going to inconvenience the public, it's up to the police. They will definitely regulate. See, any form of peaceful protest cannot be prevented.
Correct. No doubt.
But if that protest transgresses or causes inconvenience to the general public or may result in a law and order situation, police have got sufficient powers to do all within their means. That is very, very clear. No direction is required for them. But the thing is, cannot the university implement this decision? Already. Students went on. Of course, that is a form of peaceful protest. But then is there no way of reasoning out to them that, see, look here, these are all freshers who have come to join the university with very, very big dreams, and you should act. Can
had tried to reach out to them, not with motherly and not elder brotherly affection, whatever, to the extent possible. After all, they are students. But they have to be treated like students at the end of the day, so far as the university is concerned. Now, to some extent, they have mellowed down. And we have also persuaded the non-teaching staff to vacate some of the quarters and accommodate them elsewhere so that the freshers can be accommodated for the time being there in the campus for their safety and not for their.
How many students are there in the hostel?
But presently, there are 1950 seats.
1950
seats. There are two campuses, one in the Jadavpur, the other at Salt Lake.
19,500.
1,950.
Oh, 1,950
seats, hostel seats.
Hostel
seats. Apart from the messes and the paying guest facilities which the guardians arrange for themselves.
1950 is the number of students.
Is the number of seats, out of which presently there are around 1,200 or 1,300 hostel students.
1,500. Like 1,190 boarders from male and 485.
1,500, roughly 1,500.
Roughly 1,500 students.
Yes.
1,500 students in various disciplines. Now, you have got all your science, humanities. What are the courses the university say?
There are various disciplines. I just showed to your lordship.
No.
I just read out.
All these 1,500 students, are they categorized or bunched up based on the course of study?
No, not really. But it's arts, science, engineering. This is the broad faculties, and there are hostel fees. Not 15 rupees for arts, 75 rupees for arts, 150 rupees for science, 200 rupees for engineering, and 25 rupees per month for hostel fees. Since 2017, the UGC grant has.
What did you do during COVID?
During the COVID, they had to evacuate. And the situation has not recovered since then.
If suppose one thing is within the four walls, you do something, university has got the wherewithal to settle things. Things will, some heated moment, something may happen. It is resolved. The professors, head of departments, there will be a student union representative, there will be a hostel warden, he can resolve. But if this boils outside the campus and innocent people are affected, and the university is becoming famous for the wrong reasons, then cannot the university take a decision to close down the hostel? In COVID, you are able to manage.
Closing down the hostel, probably it will be difficult because there are certain courses, say the engineering and the scholars, they have to work till 10 o'clock in the laboratories.
Maybe. If there is a will, there is a way. If that is why the students' body need to be heard in the matter. There should be something, they should
There are students coming from far-fetched districts. But they have to be accommodated.
They have to. So that's a different matter. COVID, they were able to manage every situation. Let us assume maintenance has to be done. One block crumbles down, falls down. Any major condition may occur. So that's not the issue. If we will hear the students' organization. This is an in-house problem. This in-house problem has to be sorted out in-house. Normally, from my experience, the hostel warden, like the chief superintendent, is the best person to resolve. Your big vice chancellor, the principal of the institution, head of department will never. A hostel warden is almost identified as a student among themselves. So they are chosen from the faculty with that mindset. People, in fact, I have known in my hostels where the warden used to stay in the hostel.
Yes, they have to.
They stay in one of the rooms, the same size, probably single accommodation. There will be 2 students or 3 students in another room. He will be given a single accommodation. No other additional facilities. He will also use the common washroom, etc. And probably he will also be ragged or some, but nothing so serious. But if he says something in the welfare of the students will fall in line.
It's now
He is virtually a guardian.
All, as your lordships had been observing just 2 matters before this, it's all in the mindset. These are all there on record and on paper.
No, do all these things. But once it results in a criminal matter, once it starts affecting the general public for no reason and giving room to use the university as a political platform, then something serious needs.
Unfortunately, this has happened over the years.
Super has made a statement.
Let us not go by any
has made a statement. I don't know. He has made a statement in an interview. Well, everything is on how we can gather from interview to the one of the news that the hostel of Jadavpur University has tremendously influence of senior students. Especially in the main hostel, a regular gathering used to take place wherein the main attraction of the said gathering was always consumption of legally prohibited intoxicated substance. There is a statement, your lordship. I will make the union.
Now, senior students means past students.
No, seniors. The
third year.
That's the reason I said that is broadly, your lordship. One part is the hostel. This is a hostel part. Apart from hostel, the Jadavpur campus, intoxicated materials, drugs. Well, one of the union leader is making a statement. I have given it here. The day before, just a minute. Day before, yes, let me finish it. Just this sentence. Just
directed to stop the supply of alcohol, charos,
yes. Now, one of the
colleges and university.
One of the union leader who is a female who has made a statement. The university is my second home. If I can take beer and smoke in my home, why can't I do it in here? We have brought it, the videos. I will, if your lordships.
No, you implead those union.
No, union, since your lordships have said,
and you please place a full compilation of your act regulation concerning this issue.
Now, your lordships have made an observation.
That this Jadavpur University already given undertaking to this Hon'ble High Court.
Yes.
Sir, no.
That of the Jadavpur University in his affidavit, however, claimed that there was no incident of ragging in the university campus. And no information about such was there.
No, maybe, sir.
What is that undertaking? He undertakes surprise visit in the university hostel, canteen, and common room, so that the students are always kept under visit. Already undertaking.
No.
It's very nice.
Sir,
one of
things are there in black and white. What if in a given situation, they throw up the hands and say that we are not able to do it. Then what is to, that is why this.
That's exactly,
petition
that
being
is the reason the petition.
And what is to be done? If the professor is not able to convince the student to withdraw in hunger strike.
Your counseling is absolutely needed, Miller.
True, that is true. That is why, see, after.
Today first year, next year, I am the second year, I will die.
Who is?
I am the third year, I will die. So today I am being racked, but next year I will die. This is the system.
Therefore.
Your today's daughter-in-law is being racked by the mother-in-law. That daughter-in-law will become the mother-in-law. Mother-in-law will rack that daughter-in-law.
That's right. No, it doesn't happen nowadays.
Unless you separate.
All right, all. No, we need to hear the university. See, university is a creation under a statute. The statute is very elaborate. It gives tremendous powers, enough powers to the various authorities in the statute. In the event that the authorities claim that, yes, sir, we are empowered, but we are unable to implement, then we need to think what needs to be done in such a situation.
But your lordships, please, God. My lord, your lordships have made an observation. My lord, your lordships have made an observation. So far, the law and order is concerned. My lord, the police will.
The state will take care. No observation
that is outside of the campus. But inside of the campus, what would be done?
That the university will come forward with a plan. You implead the students' body, whoever it is, we will hear them and we will try to reason out and how important it is to retain the status as an alumnus of this university. You need to be proud, alumnus of this university after having graduated. And when they call you after 15 years for an alumni meet, you should be proud with pleasant memories to come back to the university, not with horrific memories.
Very good.
So that needs to be inculcated. They are very young minds. It is not that they have, as you said, that they will graduate and go as graduate. No, they will graduate. So probably they think this is it.
No, I am not saying, my lord, I am just saying this is the problem. On the very first day, I say, my lord, your lordships have to intervene and your lordships have to take a holistic view. How it has to be improved. My lord, everyone of today's Bengal is very much concerned of the Jadavpur University. Those who are, my lord, the concerned, anything.
How many of you, anybody alumnus of Jadavpur University?
Yeah.
In this courtroom number 1.
It is a very rich alumnus association. Very rich alumni association.
Now, my lord, everyone is concerned. No one.
But nobody is there.
It has to be stopped.
We couldn't match their merit.
It has to be improved. The situation of the Jadavpur University has to be improved. That is the everyone's hope. Nothing.
It can
that
be.
Your lordships can
be. Definitely it can. We are confident it can happen. Definitely it can. Every institution or every body has got a bad patch. So probably we are in a bad patch now. And things will change. Let the students be implemented.
Yes, lordships can be.
We have elaborately heard the learned.
Not
required. We'll take next time. We'll take. The petitioner is directed to implement all the recognize all the it is recognized union, the students' union of the respondent university of the Jadavpur University as respondents in this writ petition, and those unions. Students' unions be duly served with a copy of the writ petition and all annexures. The respondent university shall file a compilation consisting of compilation enclosing the Jadavpur University Act 1981 and the various ordinances, regulation and rules which have been framed by the university, the administration of the students' welfare, regulation of the hostels, and such other related matters. It can be some resolution of the Senate, syndicate, or the executive council or governing council. That also
whatever is there.
2 weeks time.
So far the rule is concerned, draft rule is concerned. In 2012, I was made a member, a chairman of the rule committee. that time in 2012. Draft rule, I don't know whether that has been adopted or not. For 1 year, I went to Jadavpur University. That time I found everything was nice.
Why can't
And
you
I
go?
gave a proposal. I tell you, Lord, I gave a proposal to the university. You are having so many faculties. Why are not bringing the law faculties? Sir, what? I will help you. You come up. Anyway, that has not been.
No, let them open law faculty. The law students and law faculty will control the entire. So
this only law faculty is not there. Everything is there. This is such a nice university.
we will make a recommendation.
Lawlessness was not
Yes, next.
conceived.
Deeply obliged to
2
you.
weeks. Yes.
Grateful.
You give some date. 5th September. 5th September.
My lord, I appear on behalf of the appellant in item number 18 and 19, my lord. And in 20 and 21, it's.
My lord, I am appearing on behalf of the
My
appellate,
lord.
my lord, on behalf of the railway authority, my lord.
My lord,
Lord,
may it be taken up on Wednesday, my lord.
Wednesday, because my lord, Wednesday, my lord, same position,
My
because my
lord,
lord, it's
Wednesday at the
regarding the
top, my
automatic
lord.
blocking system.
It's regarding the, my lord, the signaling system of
Yes.
railways. An auction was, tender was floated, my lord.
Hmm.
The writ petitioner's tender was rejected. He was technically disqualified. My lord, the writ petitioner's tender was technically, he was rejected by the railway authorities. Against that, the writ petitioner came up before this honorable court. My lord, this honorable court has held that the rejection was bad. So against that, we are one of the successful tenderer, my lord, and the lowest bidder. So, my lord, we have filed an appeal, and the railways have also filed an appeal, my lord.
Why have you filed an appeal?
My lord, because we are the successful tenderer, my lord.
Ah.
So, my lord, once the illegible tenderer, his disqualification is rejected or set aside, my lord, then my right is affected,
Oh.
my lord.
Oh, the
Successful tenderer, my lord.
successful
So
tenderer.
my right is
I
affected,
appear
my
for the
lord.
writ petition, my lord. I'll start with that question, my lord. Why I can understand the railways preferring an appeal, but my learned friend's client preferring an
My
appeal.
lord, we shall satisfy, my lord.
But what is not told to your lordship is that the tender conditions has a condition that in the event the number falls, the technical bid, the number of participants fall below 3, then without having a reverse auction, anyone can be allotted. Now, so far as my clients are concerned, we shall show to your lordship, and it has been held, that how we were made to be disqualified by simply a wrong interpretation of the
My lord, we shall
documents.
satisfy. It's our appeal, my
But
lord.
they can't have any locus.
Your turn will become the last.
But I am having the locus.
It's my appeal, my lord. Number 18 and 19 is our appeal.
We will not hear your appeal.
My-
We will hear the railways appeal first.
My lord,
Yes.
my
If
lord,
even they succeed, then
automatically.
it is up to the railways either to choose you or choose them or call for retender. But we will hear you, but we will not hear you first. The railways appeal will be heard first.
But
My lord,
even
what my
even now,
learned
my lord,
friend
it's
is
not
saying, my
that I
lord,
have
the
been
reverse
chosen.
auction, my
Only
lord.
reverse auction will take place.
My lord, what my learned friend is saying about the reverse auction, my lord, if a person
We
is
will hear
technically
you, madam. We will
disqualified.
hear you, madam.
Grateful, my.
Your appeal is subject to the railways appeal.
Exactly.
If railway appeal goes, then it is up to you to take the matter elsewhere. So we will, the right of audience will not be granted to
My lord, I'm being led by Mr. Seniors. My lord will kindly hear them on Wednesday, and my lord, subject to my lord. it
No,
may
no,
be
we
done.
will hear them, but we will
Yes,
not
my
hear your appeal first. You please tell your senior. Your seniors will not be opening the argument. It's the railways appeal will be heard first.
I shall,
And thereafter probably we will hear your appeal.
if requires.
No, my lord will kindly hear us, my lord. If required, my learned friend is saying.
If suppose they succeed,
Yes, my lord, then yes, my lord.
so you can supplement that, sir. Probably we'll come back to you after we hear Mr. Savishash.
No, my lord will kindly not do that. My lord will kindly not do that. My lord will kindly hear us, my lord. Thereafter, Mr. Chaudhary, my lord, he's a prior writ petitioner, my lord. My lord will kindly hear us, my lord. Then my lord will hear, subject to my lord, Mr.
Which
Chaudhary.
is your appeal, railways appeal?
Item number 20 and 21.
We have heard the learned advocates for the parties. Let the matter appear on Wednesday in the same position with a specific understanding that the appeals in MAT 1444 of 2023 and MAT 1455 of 2023 will be heard first.
I'm grateful.
Obliged.
That's all.
No, my lord is rising. I'm good.
আমি ready হয়ে এসেছি।
এই লিস্টটাই কি কন্টিনিউ করবে? আর দোষ করবে? হ্যাঁ, ঠিক আছে। আর অ্যাপিলের মধ্যে আরেক আসেনি। একটার মধ্যেই দুটো লিখে দিয়েছে। Original say daily list, item number 1 to 4.
My lord, I am appearing for the appellant, my lord. I am led by Mr. Learned Advocate General, my lord, in this matter. My lord, he is appearing on screen, my lord.
My lord, I oppose this application.
For direction.
Matter has to be heard finally.
Correct.
How much time it's likely to take?
My lord, I'll take, my lord, about 1 hour after Mr. Mukherjee finishes.
My lord, I'll take about an hour, my lord, not more than that.
So from tomorrow, Panchayat matter is starting.
Yes, my lord.
My lord, right, of course, my lord, is Mr. Mukherjee's appeal and petition, my lord, but I don't know because, my lord, the company, my lord, is, my lord, in liquidation now. So I don't know, my lord, what exactly, my lord.
No, my lord, I've been declared, my lord, a willful defaulter. It's not the company.
Lord, it last received your lordship's consideration on 21st April. If your lordships kindly take that, or 12th April, I'm so sorry.
12th July.
12th
July.
Kindly take the 12th April order.
Yes.
Your lordship passed an interim order, my lord, protecting Mr. Mukherjee's client from, my lord, his pictures being published, my lord, in, and my lord, but other prayers, my lord, were not granted, and my lord, it was kept for final hearing, my lord.
My lord, any date, my lord, your.
Any date, my lord, your lordship can.
25th September.
Obliged, your lordship.
Lordship.
Grateful, my lord.
At the request of the learned advocates for the parties, list the matter on 25th September.
But it is it your lordship's pleasure, it retains its position that it.
Probably it will
We
come.
can come with a, we can come with, my lord, I, from speaking for myself, can come with, my lord, a small notes on argument, indicate, and then, my lord, because your lordships already have the benefit of a very detailed order by the learned single judge, and then supplemented with our notes, my lord, it ought not to, my lord, be, my lord.
Probably it will come after the fresh cases.
Very well.
Next.
Fixed matter, item number 5.
My lord, Mr. Debojyoti Basu was appearing on behalf of the respondent in this matter. My lord, he was arguing in the matter. If my lord recalls, my lord, due to some personal difficulties, he is unable to, my lord, appear today. My lord, may I have 1 day's accommodation, your lordship? I am praying. If it can be.
No problem.
Grateful, so grateful, my lord.
For admission, item number 6.
At the request of the learned advocate for the respondent, list on so and so date.
Grateful.
Item number 6.
Yes.
The revenue is appeal, my lord. My lord, here in this case.
Yes.
Lord, the question which falls for your lordship's kind consideration is, my lord, whether the Newtown Kolkata Development Authority, my lord, qualifies for a local authority which is entitled to an exemption under subsection 20 of section 10, my lord, of the Income Tax Act 1961. Lord, the assessing officer, my lord, held in favor of the assessee. My lord, the regular assessment was filed. Thereafter, my lord, under the computer-aided scrutiny selection, my lord, the case was selected for scrutiny, my lord, on the ground of large exempt income. Now, my lord, the assessing officer comes to the conclusion, there is an abrupt conclusion, my lord, that the assessee, my lord, has shown this income and I accept this. Lord, I shall take your lordship to the assessment order. My lord, there is an audit objection raised by the audit party. Subsequently, my lord, the commissioner, principal commissioner of income tax, my lord, passes an order under section 263 and my lord,
sends the file back to the assessing officer saying, my lord, that this is an order which is erroneous and prejudicial to the interest of the revenue. Lord, this order is carried in appeal before the ITAT, before the ITAT by the assessee. And Lord, the ITAT upturns the order of the commissioner on 4 grounds. Lord, one is that the commissioner has passed the order at the suggestion of the audit party. Second, that the commissioner's order is actually an order which is a change of opinion. The assessing officer had taken a plausible view or a possible view, and the commissioner's view is only a change of opinion. And third, my lord, is that even on merits, NKDA, that is, my lord, the Newtown Kolkata Development Authority, is an authority which is entitled to exemption under section 10(20) of the Income Tax Act. My lord, on this periphery, my lord, we have, my lord, filed our memo of appeal. My lord, upon going through it, my lord, yesterday, my lord, I had a talk with my learned senior friend also, my lord. There are two more substantial questions, my lord, which subject to your lordship's kind, my lord, permission. My lord, these two should also, my lord, be there if your lordship feels, my lord, because these are involved. I'll be making my arguments on this also. Basic, my lord, because this had to be there. This had to be there.
Subject to the 2 questions which has now been raised, questions can be raised. There is no difficulty. But it is a case whether no inquiry was at all conducted or inadequate inquiry was. It's not a question of change of opinion. From the facts of the case, I will place at the relevant time that inquiry was conducted. So that is the amendment to section 263.
Yes. Now, my lord, I take your lordship first, my lord, to the order of assessment. The assessment order, my lord, is page 11. Page 11 of the stay application. My lord, that is, my lord, the documents which were filed before the ITAT. My lord, that was submitted by my learned senior friend, my lord, on the last occasion. Lord, of the stay application, my lord. Small. Yes, page 11. Lord, return of income for the assessment year 2015-16 was e-filed by the assessee on 3/3/2017, declaring a total loss at minus such and such. Subsequently, the return was selected for scrutiny through CASS, and notice under section 143(2) of the IT Act 1961 dated such and such was issued and duly served upon the assessee. Thereafter, the notice under section 142(1) of the IT Act was issued and duly served upon the assessee, requesting him to produce the details as required in the notice. In response to the said notices, Sri B.R. Datta, FCA authorized representative of the assessee, appeared from time to time and filed submissions supporting relevant documents and explanations which were examined in course of the assessment proceedings. It is explained that the assessee is a local authority constituted by the government of West Bengal by notification number such and such dated 27 June 2008, engaged in developing roads, water supply, street lighting, drainage, sewerage treatment and disposal of sewerage, public works, tourist spots, open spaces, parks, landscaping and playfields and other utilities in its cover area. In view of the discussions, the total income of the assessee is computed as under. Now, my lord, this is the order which is passed by the assessing authority. My lord, after that, my lord, if your lordship turns over the page, my lord, page 14.
Audit report.
Audit report. My lord, page 14 is the audit objection. I will not trouble your lordship, my lord, with the merits of the audit objection. Now, my lord, lordship will kindly take page 16, which is the order passed, my lord, under section 263 of the Act. Lord, in the case under consideration, order under section 4.
Before that, page 14,
yes,
that unnumbered second paragraph.
Yes.
What was the view of the audit?
My lord, auditor says, my lord.
Audit is of the view.
Yes. Audit is of the view that exemption under section 10(20) of the Income Tax Act is available to those authorities or bodies only which fulfill the criteria as contained in explanation to this section inserted by Finance Act 2002. As per clause E of Article 243P of the Constitution of India, municipality means an institution of self-government constituted under Article 243Q, which prescribes that prerequisite for any body or authority to qualify as a municipality is that it should be self-governing, and its members should be elected either directly or indirectly from the territorial constituencies in the municipal area. NKDA had been constituted through the NKDA Act 2007 and not under Article 243Q of the Constitution, which is a prerequisite for qualification of any authority, body as local authority. Moreover, there is no provision in the NKDA Act for election of its members, directly or indirectly, and all members are nominated by the government of West Bengal.
But the government of West Bengal has notified it as a local authority.
Has notified it as a local authority, yes.
In 2008.
Yes. Has notified it as a local authority, my lord, but that is not a notification, my lord, in terms of section 243P. Lord, 243P of the Constitution of Lordship states, my lord.
John, Constitution, Income Tax Act.
Your Lordship will take 243P definitions. Now, your Lordship will kindly come to E, municipality. Lord, municipality means an institution of self-government constituted under Article 243Q. Lord, the next article is 243Q. Now, my Lordship will see, there shall be constituted in every state a Nagar Panchayat by whatever name called for a transitional area, that is to say an area in transition from a rural area to an urban area, a municipal council for a smaller area, urban area, and a municipal corporation for a larger urban area in accordance with the provisions of this part, provided that municipality under this clause may not be constituted in such urban area or part thereof as the governor may, having regard to the size of the area and the municipal services being provided or proposed to be provided by an industrial establishment in that area, and such other factors as he may deem fit, by public notifications specified to be an industrial township. Thereafter, my lord, it's important. In this article, a transitional area.
One submission, my lord, perhaps that will cut the matter short. It is not my case that NKDA is a municipality under Article 243P.
But does it discharge any of the duties of
Each of the duties.
Suppose there is a constituted local body. The government has got powers because even under the Panchayat Act, Municipalities Act, deep pervasive control, governmental control is there. If suppose the government decides to hive off some of the activities of an elected body, entrusts it to another governmental organization with, once again, as you said, government nominees, no election. Will that new organization, if it was not existing, the duties which it had to be carried out by a local body.
Right.
And if this is hived off and vested with another authority, the character of the work done by the authority will undoubtedly be one of the duties of an elected municipality. If that is so, substance over form.
Yes, my lord. And my lord, if your lordship takes section 20, clause 20 of section 10, my lord, my case was all along that it is in the nature, it partakes the character of a municipal committee. Not
but I shall answer to both these questions, Lord. I shall answer. Lord has made it clear.
So it is not in dispute that it is not a municipality.
Therefore, Lord, I will not labor, my lord, to show that it is not a municipality.
It is also not in dispute that the functions or duties and responsibilities of this authority are that which were vested with the municipality,
right,
or are deemed to have been vested with the municipality if this authority was not created.
Right.
Now, my lord, only one thing on this. Before that, my lord, your lordship will then kindly take section 10, subsection 20.
No, before that, can we have some literature on this authority, NKDA?
Yes, ma'am.
Yes, yes, that is there.
How it was
Your lord, yes,
constituted?
your lordship will
That
kindly
your
see.
lordship will find in my compilation. Sure.
So it was by a state legislation?
Yes, it was by state legislation. It was by state legislation. That is why, my lord, I dissuaded myself, my lord, from placing Champalal, my lord, which was subsequently disapproved by the Honorable Supreme Court, my lord. But Justice Chelameshwar's judgment, my lord, Champalal, where it said, my lord, that there has to be a presidential notification under, my lord, Article 243Q. My lord, that was not there. Therefore, my lord, the Rajasthan body, my lord, was struck down as unconstitutional. My lord, in 2021, the recent most judgment, my lord, disapproved that, saying that if there is a legislation, that will hold good. But then, my lord, in that case, there has to be an elected body. Lord, I shall make my submissions on that purpose. Since my learned friend has said it is not a municipality, I will not labor, my lord. But that is important. It has to be an elected body, my lord, because self-government, my lord, the introduction of Part 9A into the Constitution by the 73rd and the 74th Amendment was with the idea, my lord, to bring about, my lord, decentralized democratic power. My lord, it is not nomination. It has to be, my lord.
We are direct witnesses how the democratic power. Tomorrow, we are going to really see what is the democratic.
Yes, yes.
But can I come back in a minute?
Now, my lord, lordship will kindly take, my lord, the bill first.
Page 9.
Page 9, yes. My lord, social commitment needs to be judged in terms of historical and social conditions of the society. For long-term social gains, it is considered imperative to formulate a balanced planning to address the housing problem of the people who used to reside in Kolkata and peripheral areas for livelihood due to expansion of technological, industrial, and business activities. The development of New Town Kolkata is for all practical purposes a project which will be developed in phases and may likely take 10 to 15 years to come to a finality in shape with all amenities required for a modern town. This time gap is a transition period for the area to be declared as municipality. During this period, allottees of plots are likely to be engaged in various activities like construction of residential and non-residential purposes, setting up institution and other commercial activities for which various civic amenities and supportive services are to be provided. A body to act as service provider to this growing area is the crying need of the hour. Moreover, with a view to providing civic amenities and services which are required for a highly urbanized planned township, recurring charges like fees, development charges, etc. are to be imposed. In order to ensure the maintenance of civic services and other amenities and to provide for the planned development in the areas in New Town, Kolkata, an authority is required to be constituted. It was with this view, my lord, that the act was promulgated.
Yes.
Your lordship will kindly take, my lord, page 55. My lord, page pagination is at the bottom, my lord. At the bottom.
Yes.
Lord, lordship will see the preamble. An act to provide for the planned development in the areas within New Town, Kolkata, and for matters connected therewith or incidental thereto. Whereas it is expedient to provide for the planned development in the areas within New Town, Kolkata, and for matters connected therewith or incidental thereto, it is hereby enacted such and such, such. My lord, therefore, this act was enacted for the planned development of the areas within New Town, Kolkata. Now, my lord, before I proceed further, may I take your lordship to the present section, my lord, 1020, and my lord, the earlier section 1020, my lord, which was there prior to deletion of a portion thereof. Your lordship will kindly take page 2 of this bunch itself. My lord. Page 2. At the bottom.
Section 15 of this act,
Yes.
at page 58, gives the powers and functions.
Yes, yes.
And these are all undoubtedly municipal functions.
Yes, yes. There's no doubt, my lord. I'll make my submissions on this, my lord. But whether, my lord, merely because they exercise the powers of municipal functions within the meaning of the Income Tax 1968, Income Tax Act 1961, they will, my lord, fall within the definition of the local authority. After, my lord, carving out of a particular deletion of a particular provision thereof, my lord, is the question, my lord, which I would like to develop.
If suppose these municipal functions or these functions would fall within 243W.
243W, it will only be, my lord, if it is an elected body. It has to be an elected body.
Maybe subject to the provisions of this constitution,
Yes.
the legislature of state may by law endow the municipalities with such power and authority as may be necessary to enable them to function as institutions self-governed, such laws provision devolution. With respect to preparation of plans for economic development and social justice. That appears to be the intention of this enactment.
Yes.
Performance and functions and implementation of schemes as may be entrusted to them, including those in relation to matters listed in 12th schedule.
No, my lord, but this is subject to the provisions of this constitution. My lord, subject. My lord, if your lordship sees, these are all, my lord, my lord, chapters and provisions under part 9A of the constitution. Part 9A, my lord, was introduced with a purpose. But part 9A, municipalities, my lord, this was introduced by the Constitution 74th Amendment Act 1992 with effect from 1st of June 1993. My lord, it had a laudable purpose. My lord, may I show the purpose then, my lord? Then I shall proceed. My lord, if your lordship takes. My lord, this is 2006, volume 8, SCC, page 352. Lord, paragraph 12. It may be noted that part 9A was inserted in the Constitution by virtue of the Constitution 74th Amendment Act 1992. The object of introducing these provisions was that in many states, the local bodies were not working properly, timely elections were not being held, and the nominated bodies were continuing for long periods. Elections had been irregular and many times unnecessarily delayed or postponed, and the elected bodies had been superseded or suspended without adequate justification at the whims and fancies of the state authorities. These views were expressed by the then Minister of State for Urban Development while introducing the Constitution Amendment Bill before the Parliament, and thus the new provisions were added in the Constitution with a view to restore the rightful place in political governance for local bodies. It was considered necessary to provide a constitutional status to such bodies and to ensure regular and fair conduct of elections. In the statement of objects and reasons in the Constitution Amendment Bill relating to urban local bodies, it was stated, in many states, local bodies have become weak and ineffective on account of a variety of reasons, including the failure to hold regular elections, prolonged supersessions, and inadequate devolution of powers and functions. As a result, urban local bodies are not able to perform effectively as vibrant democratic units of self-government. Having regard to these inadequacies, it is considered necessary that provisions relating to urban local bodies are incorporated in the Constitution, particularly for putting on a firmer footing the relationship between the state government and the urban local bodies with respect to the functions and taxation powers and arrangements for revenue sharing, ensuring regular conduct of elections, ensuring timely elections in the case of supersession, and providing adequate representation for the weaker sections like the scheduled caste, scheduled tribes, women. Lord, all this is, my lord, conspicuously absent here. My lord, all of them, my lord, are government bodies. My lord, somebody, my lord, officiating chairperson, my lord, some IAS officer, some, my lord, WBCS officer. These are not, my lord, units of self-government.
Admittedly, it is not an elected body.
Yes.
But the duties which are discharged by them are in terms of, one second. Twelfth schedule. Article 245, 243W, 12th schedule, urban planning, including town planning, regulation of land use, roads, bridges, economic, social development, water supply, public health, fire service, urban forestry, slum improvement. All these you can find in section 16, more or less.
That's there, my lord. But in order to be entitled to exemption, my lord, they have, my lord, that is why, my lord, the constitutional entire, my lord, if your lordship sees, my lord, section 10, subsection 20.
Will you not appreciate the substance or form?
My lord, that is
in effect, what do they do? Yes, they are not elected. But if they were not there, this function would have been under the municipality. And if the functions had been done by the municipality and they claimed a relief under 1020, you would have granted. But he is not an elected body for sure.
My lord, there is a difference here. My lord, the difference is in the deletion of, my lord, section 20, subsection 20A. Lord, your lordship will kindly see that. That is why, my lord, I was trying to, my lord, take your lordship to that section first.
Section 1020.
Yes, section 1020, my lord. Your lordship takes, my lord, page 2 of the bunch.
Oh, in the bunch it is there. Yes.
Lord, about the bottom of the page, my lord. Section 20, 1020, prior to amendment by the Finance Act 2002. The income of a local authority which is chargeable under the head income from house property, capital gains, or income from other sources, or from a trade or business carried on by it which accrues or arises from the supply of a commodity or service, not being water or electricity, within its own jurisdictional area, or from the supply of water or electricity within or outside its own jurisdictional area. Now, my lord, after, my lord, the 2002 amendment, an explanation is inserted to it. The lordship will see the explanation. Explanation. For the purposes of this clause, the expression local authority. Now, my lord, that was a case where, my lord, all these local authorities, new town development, urban authorities, my lord, all these authorities, my lord, were claiming exemption on the same analogy, my lord, which your lordship just now drew. Now, my lord, what is happening here? Explanation. For the purposes of this clause, the expression local authority means I, Panchayat, referred to in clause D of article 243 of the Constitution, or municipality as referred to in clause E of article 243P of the Constitution, or municipal committee and district board legally entitled to or entrusted by the government with the control or management of a municipal or local fund. My lord, that was my learned friend's submission. He is a municipal committee and not a municipality. My lord, I shall, my lord, demonstrate that as well. 4. Cantonment Board as defined in section 389 of the Cantonments Act 1924. Now, my lord, there is one more thing which happened. My lord, the earlier avatar of 1020, my lord, had a section 10 subsection 20 capital A that was deleted. My lord, kindly read that. Any income of an authority constituted in India by or under any law enacted either for the purpose of dealing with and satisfying the need for housing accommodation or for the purpose of planning, development or improvement of cities, towns and villages, or for both. My lord, this was deleted by, my lord, reading municipal functions into, my lord, the NKDA Act, and, my lord, holding it to be a municipality, my lord, for the purposes of this section. My lord, in my very respectful submission, we will be bringing exactly that, my lord, which has been deleted. My lord, planning, development, improvement of cities, towns and villages, or both. My lord, this is the very purpose which, my lord, the Act, NKDA Act, my lord, seeks to achieve. That has been done away with, deleted. My lord, has been dealt with by several judgments of the Honorable Supreme Court, which I shall be placing before your lordship, my lord, one by one. My lord, it is in this perspective, my lord, that your lordship will proceed, my lord.
What did the commissioner do?
Yes. Now, my lord,
Focus.
page 16, 1-6. My lord, 1-6 of the stay petition, my lord. Yes. Lord, in the case under consideration, order under section 143(3) of the Income Tax Act 1961 was passed on 13/12/2017, determining the total loss at 1 crore such and such. Consequent upon examination of assessment record, it was found that the assessing officer had completed the assessment without making necessary inquiries and verification in respect of allowability of exempt income. It is apt to add here that failure to conduct necessary inquiries and investigations renders an assessment order erroneous as well as prejudicial to the interest of revenue. The facts leading to such an inference were patent from the documents available on record. The AO did not go into the documents during the assessment proceedings and apparently failed to bring on record allowability of exempt income of rupees such and such under section 1020 of the Income Tax Act. Accordingly, the order under section 144(43)(3) dated 13/12/2017 passed by the assessing officer was prima facie found to be erroneous insofar as it was prejudicial to the interest of the revenue. Resultantly, a show cause notice in the following terms was issued. Now, my lord, the show cause notice is quoted. My lord, I am reading the notice, my lord.
Yes,
Reasons
please.
for the notice. Section 1020 provides exemption of income of local authorities, that is Panchayat, municipality, municipal committee, district board or cantonment board only. Any authority cannot be a local authority for the purpose of exemption under section 1020 of the Act, even if they may be deemed to be local authority under central or state legislation. This legal position was clearly explained by the CBDT circular number such and such regarding the explanatory notes to Finance Act 2002, when the amendment was brought in by the Parliament by deleting section 10, subsection 20A of the Act. Article 243Q of the Constitution of India requires that a transitional area, a smaller urban area, or a larger urban area means such area as the governor may, having regard to the population of the area, the density of the population therein, the revenue generated for local administration, the percentage of employment in non-agricultural activities, the economic importance or such other factors he may deem fit, specify by public notification for the purposes of this part. In this case, no such notification by the governor in terms of section 243Q exists. NKDA Act says New Town, Kolkata means the area described in Schedule 1 of NKDA Act. The area as mentioned in Schedule 1 does not mention it as municipal area or a transitional area as mentioned in Article 243Q of the Constitution of India. The notification in the assessee's case is not akin to formation of a municipality or Nagar Panchayat. NKDA Act was passed for a very specific and limited purpose only. Nowhere it is mentioned in NKDA Act that a municipality is formed in New Town, Kolkata as referred to under Article 243PE of the Constitution of India. All the members of the assessee, including the chairman, are nominated by the state government. After Constitution 74th Amendment Act 1992 was introduced and adopted by the West Bengal Municipal Act, a municipality cannot be constituted solely with the nominated members by a state government. In view of the above stated facts, the assessee should not have been allowed benefit of section 1020 of the Act, erroneous and prejudicial to the interest of the revenue. While making an assessment under section 143(3) of the Act, the assessing officer ACIT Circle 51, Kolkata did not make any inquiry regarding allowability of the provisions of section 1020 of the Act in the light of the facts of the case and existing legal provisions. In view of the above, the order under section 143(3) dated 13/12/2017 is considered erroneous insofar as it is prejudicial to the interest of revenue, and the said order is required to be revised under section 263 of the Act. You are hereby offered an opportunity of being heard in accordance, my lord, he is called upon. Now, my lord, paragraph 3 is the response of the SSE. Lord, may I place the response? My lord, the italics portion, it is submitted that the above mentioned notice is without jurisdiction. The SSE is a local authority as defined under section 1020 of the Income Tax Act 1961. This is also accepted by the department at the time of issuance of PAN, as the fourth character is in PAN is L, and hence is a local authority under the Income Tax Act 1961. Further, at the time of passing of assessment order, the assessing officer has stated as under. It is explained that the SSE is a local authority constituted by the government of West Bengal by notification number such and such, engaging in developing roads such and such, such and such, such and such in its covered area. My lord, I am skipping the paragraph. Thus, the assessing officer has applied his mind to the facts and has come to a concrete finding that the assessee is a local authority covered under section 10, subsection 20 of the Act. The said notice issued by you seeks to reapprise facts and evidences to come to a different finding and is merely a change of opinion. This is not within the purview of jurisdiction under section 263. Reliance is placed on the following decisions. On merits, without prejudice to the above, it is submitted that in para 4 of your notice, wherein you have stated that the governor has not notified Newtown as a transitional area, is factually incorrect and without any basis. It may be noted that Article 243 Q1A provides as under. There shall be constituted in every state, my lord, the article is quoted, Nagar Panchayat by whatever name called for a transitional area, to say an area in transition from a rural area to an urban area. Newtown has been notified by the governor of West Bengal as planning area, my lord, under the West Bengal Town and Country Planning Development Act 1979, in short WBTC Act. Thus, the Newtown area and various other areas have been subsequently been notified by the governor by various notifications which are attached as Annexure A. WBTC Act provides in its preamble as under. An act to provide for the planned development of rural and urban areas is in West Bengal and for matters connected therewith or incidental thereto. It is further to be noted that under section 9(1) of the WBTC Act 1979, the Act empowers the governor to notify the planning area. Copy of the relevant sections are attached as Annexure B. Thus, Newtown being a planning area is a transitional area notified by the governor of West Bengal as required under Article 243Q. It may be further noted that in para 5 of the said notice, you have pointed out that a municipality cannot be constituted solely with the nominated members of a state government. It is humbly submitted that Article 243R, which provides for composition of municipality states as under. It is in 243(1)R1. It is important to note that Article 243(R1) provides that the article is subject to subclause 2. In Article 243(R2) provides for state to make legislation for representation of municipality by persons having special knowledge or experience in municipal administration. It is further submitted that Section 11 of the WBTC Act provides the power to the state government to make such election. In Section 11(3), the state government has been given the power to appoint members to the planning authorities as envisaged. Thereafter, my lord, the commissioner's, my lord, findings.
Commissioner has not gone into anything.
No, my lord, but if lordship sees, my lord, paragraph 21.
He says improper inquiry or some inquiry not detected, etc.
Yes, my lord, page 21, my lord. Page 21, last paragraph, my lord. My lord, has some sense, my lord, so far as this exercise of power is concerned. My lord, last 3 lines. The correct provisions of law were not examined by the assessing authority. The finding of the AO was arbitrary and perverse.
Yes.
The assessing officer failed to apply his mind to the case and hand in all perspectives. To sum up, the concept of an order prejudicial, my lord, this is Lord, the correct provisions of law, my lord, this is the only question. My lord, if you apply the correct, my lord, I will get the right answer, my lord, if I ask the right question. My lord, I have asked the wrong question, my lord, I have got the wrong answer. My lord, I have proceeded, my lord, on that. Now, my lord.
We'll come to the tribunal, page 44,
Yes.
page 44. Para 8.
We have heard the rival submissions and perused the relevant material available on record. From the records, we find that the assessee is constituted under the West Bengal Act of 2007, under the name and style of New Town Kolkata Development Authority Act 2007, which was published in the Kolkata Gazette on 30th June 2008 and with a notification number such and such, when it received the assent of the Honorable President of India, a copy of which is placed at page number 47 of the paper book. Under the said act, detailed provisions have been made in chapter 4 and the powers and functions of the said authority in section 16, 17 and 18 of the act, which are reproduced as under for the sake of ready reference. Lord, powers and functions, Lord, are quoted. We also observe that the said authority is entitled to exercise powers of levy of taxes and collection of taxes under chapter 7A, which is reproduced as under. My lord, this is according to the R.C. Jain's case, my lord. This was the test laid down. Thereafter, my lord, we have also examined the statement of objects and reasons in the New Town Kolkata Development Authority Bill, which is provided in part 4 of the Kolkata Gazette, which is extracted as under, my lord. Bill I place, my lord, and that.
Yes.
Paragraph 11. On the basis of the above documents, we observe that undisputedly the NKDA was constituted for the purpose of various activities as provided in the Act, and nowhere it is engaged in development of any residential accommodation or commercial spaces and selling thereof, but primarily engaged for developing roads, water supply, street lighting, draining, sewerage treatment and disposal of sewerage, public works, open spaces, park, landscaping, and play fields and other utilities in the area. The learned counsel also referred to page 147 of the paper book to show the approval that NKDA is entrusted with local funds, which is also a condition for a local authority under section 1020 explanation 3. On the basis of these evidences, we are of the view that the assessee is certainly municipal committee entrusted with local funds meeting various parameters as envisaged in the definition of local authority and is entitled to exemption under section 1020 of the Act. Therefore, my lord, the conclusion reached by the ITAT is that the authority qualifies for a municipal committee. My lord, it is on this basis, my lord, that the authority, that the ITAT, my lord, has held against the revenue. We have also examined the assessment order and find that the learned assessing officer has specifically made observations that the assessee is entitled for exemption under section 1020 of the Act as a local authority on the basis of evidences filed by the assessee. In our opinion, the learned assessing officer has taken one of the plausible views with which probably the learned PCIT was not in agreement, as he was holding a different view on the issue, but the PCIT cannot invoke jurisdiction under section 263 of the Act. We have also examined the audit memo issued by the Office of the Director General of Audit, Revenue Audit Direct Taxes to the ACIT, pointing out that audit is of the view that exemption under section 1020 of the Income Tax Act is available to those authorities or bodies only which fulfill the criteria as contained in the explanation to this section inserted by the Finance Act 2002. The said memo is extracted as under. My lord, the audit objection is extracted. Thereafter, my lord, this audit objection.
But from the year 2007, they have been treated as a local authority. All in a sudden in this assessment year 15, 16, you now turn back and say.
My lord, this happened because of the judgment. That is, my lord, where the change of opinion aspect will come. My lord, this view was not clear prior, my lord, to this, my lord, this market committee judgment, which forms part of the compilation also. My lord, there it was explained, my lord, what a municipal committee means. My lord, that is why, my lord, the commissioner has said.
That is not the basis of 263.
My lord, it says legal provisions have not been gone into. My lord, that is.
No, show cause notice, that is not the basis.
My lord, show cause notice definitely says, my lord, that 243 PQ, my lord, it refers to that. My lord, I'll place the judgment also. I'll place the judgment also.
No, that was not the reason why
My lord, if your lordship sees the reasons. for
the
issuance-
audit committee's report may have some reasons. But if you see the reasons why the commissioner issued the show cause notice, page 17.
Yes. My lord, section 1020 provides exemption of income of local authorities, that is Panchayat, municipality, municipal committee, district board or cantonment board only. Any authority cannot be a local authority for the purpose of exemption under section 1020 of the Act, even if they may be deemed to be a local authority under the central or state legislation. This legal position was clearly explained by the CBDT circular number such and such regarding such and such explanatory notes to finance such and such, such and such. Article 243Q of the Constitution of India requires that a transitional area, a smaller urban area or a larger urban area means an area as the governor may, having regard to the population of the area, the density of the population therein, the revenue generated, Lord. He has quoted, Lord, from the provisions of the Constitution. In this case, no such notification is there. Then, Lord, elected members, the SSC should not have been allowed the benefits. My lord, it is all, my lord, on the interpretation of section 10, subsection 20A, read with the constitutional provisions.
But the assessing officer, he has taken a different view
My lord, assessing officer takes a view.
on the audit report.
Yes, the view, my lord, that is interesting, my lord. I must
Ah,
place that. That is
yes.
very, very interesting, my lord, because the conclusion and the reasoning of the assessing officer, my lord, when this audit objection, my lord, is sent to him, my lord, subsequently, your lordship will find that. My lord, the assessing officer's view, my lord, begins from page 54.
In
Lord-
fact, the clear copy is, I think,
There.
in page number
My lord, it should be there here.
23, correct? No, in that they have quoted it.
Yes.
No, this is different. There's assessment order, page
No,
54.
my lord, your
After
lordship will-
setting out the facts, then he refers to section 1020,
My lord, this
1020A,
is the assessment order, my lord, giving effect to the commissioner's order.
then CBDT circular. Please come directly to page 56.
Yes.
The implications of omission of 20A is explained to CBDT while explanatory notes on the provisions are directed. Explains also. Existing provision 20 so also, income to a local authority chargeable and so.
Lord,
He is exempt from.
If your lordship will kindly take page 58.
It is at page 247 of the compilation. It's a better copy.
That may be a more readable one. This is easy to handle.
My lord, page 58, my lord, your lordship will get the views, my lord, after the discussion.
No, before that, Mr. Rai, before that, page 56.
Yes, please.
56,
Yes.
para 12.2, middle
Yes,
of that.
Through
12
Finance Act 2000.
yes.
This exemption has been restricted to the panchayats and municipalities as referred to in Article 243D and 243PE of the Constitution respectively. Municipal committees and district boards legally entitled to or entrusted by the government with the control or management of a municipal or local fund, and cantonment boards as defined under Section 3 of the Cantonments Act 1924. The exemption under Clause 20 of Section 10 would therefore not be available to agricultural marketing societies and agricultural marketing boards, etc., despite the fact that they may be deemed to be treated as local authorities under any other central or state legislation. Exemption under this clause would not be available to port trusts also. This amendment will take effect from 1st April 2003 and will accordingly apply in relation to the assessment years 2003-4 and subsequent assessment years. The eligibility of the assessee for exemption of income in the capacity of municipality lies with the answer whether it fulfills the conditions as laid down in Article 243P and 243Q of the Constitution of India. The composition and constitution of a municipality is laid down in Article 243R and 243S. Article 243 of the Constitution of India, my lord, Constitution of India is, my lord, the article is quoted. My lord, E is relevant because E is what is mentioned. Yes. My lord, the provisions are quoted. Thereafter, my lord, 243Q is quoted.
Page 58, para 4.
Yes, page 58, para 4. In view of the above, the following points are noted. An authority cannot be a local authority for the purpose of exemption under section 1020 of the Income Tax Act 1961, even if it is formed under any central or state legislation. B. Article 243Q requires that a transitional area, a smaller urban area, or a larger urban area means such area as the governor may, having regard to the population of the area, the density of the population therein, the revenue generated for local administration, the percentage of employment in non-agricultural activities, the economic importance, or such other factors as he may deem fit, specify for public notification for the purposes of this part. In this case, the SSE claims to be a Nagar Panchayat. It has the jurisdiction over the area called New Town, Kolkata, as mentioned in Schedule 1 of NKDA Act. The public notification in this regard were perused. Nowhere the area has been declared as municipal area or a notified area for a Nagar Panchayat. Moreover, nowhere the area has been mentioned as a transitional area from rural to urban. It has been described as New Town Planning Area in the public notification. The population of New Town, Kolkata was such and such in census such and such. Article 243S mandates a municipal area to be divided into wards. The SSE does not fulfill Article 243S of as wards are not formed in New Town. So question of ward committees does not arise. All the members of the SSE, including chairman, are nominated by the state government. After Constitution 74th Amendment Act 1992 was introduced, a municipality cannot be constituted solely with nominated members by the state government. Had it been so, the very concept of self-government is defeated. The SSE does not fulfill any of the above mentioned provisions of the 74th Amendment Act, which are mandatory in nature. NKDA Act does not mention the SSE as a municipality or Nagar Panchayat. It defines the SSE as an urban local body corporate. The perusal of functions enumerated in NKDA Act shows that the SSE is entrusted with only the remunerative projects like property, building, street, private street, water supply, drainage and sewerage, solid waste, markets, and fire safety. The 12th schedule of the Constitution provides an illustrative list of 18 functions that may be entrusted with a municipality. NKDA is not entrusted with projects like poverty alleviation, slum development, promotion of education, safeguard of weaker sections of society, statistics of births and deaths, etc. The SSE has obtained a PAN and filed IT return. No municipality or Nagar Panchayat is required to obtain a PAN, nor it is required to file IT return. Now, my lord, this is what the assessing officer says. And thereafter, in view of the discussion, it is seen that the SSE does not fulfill the criteria of a local authority as per explanation to section 1020 of the Act. However, audit objection is not accepted as the case is not tested in court of law. Therefore, my lord, he
is playing it safe both ways.
So therefore, my lord, even the assessing officer, my lord, believes that, my lord, the conclusion is not correct. Now, my lord, but the ITAT, my lord, says that he did not.
Though the ITAT uses the word plausible view, in paragraph 11, they give a positive finding. Page 49, para 11, last 5 lines. On the basis of the evidence, we are of the view SSE is certainly a municipal
committee. Yes. That I say. Lord, now I shall demonstrate.
Earlier, they were saying that they were Nagar municipality,
yes,
etc.
Yes.
They have given up the plea.
Yeah.
They brought it down to municipal.
Now, my lord, this municipal committee plea, my lord, comes before the ITAT. It was not before the commissioner. All through, my lord, it was Nagar Panchayat. Now, my lord, whatever, my lord, I shall demonstrate it is not a municipal committee either. That I shall demonstrate. Now, my lord, the next if your lordship takes, my lord, the next basis, my lord, because there are three grounds on which, my lord, the ITAT held against the revenue. My lord, if lordship takes, my lord, page 59. Page 59. Lord, he says, my lord, that the commissioner acted on the suggestion of the audit party. Therefore, my lord, it is not an exercise of discretion, but it is an exercise of power under influence. And therefore, my lord, such exercise of power is not an exercise of power under section 263, and it should not be countenanced, it should not be supported. My lord, this was the view of the ITAT. My lord, on these three counts, my lord, the ITAT, my lord, holds in favor of the SSC, and my lord, rejects the revenues, my lord, revenues contention, my lord, and sets aside the order, my lord, passed by the commissioner. No, my lord. Your lordship has gone, my lord, through the order passed by the PCIT under section 263. There is no reference, my lord, to the audit objection. It does not appear on a reading of the order, my lord, that the order was passed at the suggestion of the audit party. My lord, he has applied his own mind. My lord, the reasons, my lord, recorded in the show cause notice show. His conclusions show, my lord, he says that you have not, my lord, your lordship saw, my lord, what the assessing officer did, my lord, when he was, my lord, faced with the audit objection. My lord, he brings out census records. My lord, he brings out a lot of things, my lord, which could have been done at the first stage only, my lord, to negate the plea. That was not done. Therefore, my lord, it is not so simple, my lord, to say that the commissioner went wrong in saying that inquiries which ought to have been performed have not been performed. Now, my lord, on this, Lord, may I cite my lord, an honorable single bench judgment, my lord, was relied on before the ITAT, my lord, where it has been held that if the commissioner acts on the suggestion of the audit party, then the order, my lord, should be squashed on that ground alone. My lord, another single bench had an occasion, my lord, to refer to it, and I shall be referring, my lord, to other judgments of, my lord, the judgment which was relied on, my lord, first this. I'm sorry, my lord, that your lordship will take later on. This was the judgment which was relied on. Lord, this is Jeevan Lal versus Additional Commissioner of Income Tax and others. Lord, this is 108 ITR 407.
But this issue needs to be gone into on facts.
Yes.
We need to compare what was his finding. etc.
Yes, yes.
But undisputably, it was the starting point.
Lord, may have been, Lord, that may not have been explained away, my lord, by
But
different
he doesn't
judgments.
say merely because audit said, I am doing it. He has
Yes,
not said.
no, he has not said so. My lord, if your lordship sees, my lord, the next judgment which I handed up to your lordship, lord, this is 1999, lord, 238 ITR 143.
Oh.
Lord, JCIT Limited and another versus Commissioner of Income Tax and others. Your lordship will see, my lord, paragraph 4. That was the submission. Dr. Pal submitted that there are cases showing that the writ court can interfere even at the preliminary stage where only notice has been issued. He gave the case of Jeevan Lal and drew my attention to the passage at page 412. In that case, Sabyasachi Mukherjee J, as his lordship then was, passed an order even as against the notice under section 263 opining that the order was passed by the commissioner at the suggestion of the audit department of the revenue and not by the additional commissioner in exercise of his quasi-judicial discretion. My lord, this was the submission made. But if your lordship sees the conclusion, paragraph 23.
Yes.
Para 23. However, examine the impugned notice as I might, it does not appear to me to be possible to opine even at this stage that there is the slimmest or the slightest likelihood at any stage for any court to come to the conclusion in any view of the matter that the commissioner did not apply his own mind. If the commissioner did apply his own mind, his jurisdiction to issue notice gets supported, although not in full. Again, if the text of the notice is examined, it cannot ever be said that the jurisdiction was exercised on circumstances and grounds which cannot reasonably be used by the commissioner ever to issue a notice under section 263. If these are borne in mind, then one would search in vain, even in the petition and the annexures thereto, for the existence of some indication of the commissioner issuing the notice mala fide, or as alleged in paragraph 19 of the writ petition, as a mere cloak or pretense to start a fishing inquiry. Therefore, my lord, it has to be culled out from reading the notice itself.
Yes.
No, my lord, this view, my lord, has been, my lord, taken by different high courts across the country. My lord, the next judgment is, my lord, 242 ITR 490. My lord, this is a division bench judgment of the Madras High Court.
Yes.
Paragraph 10, my lord. Paragraph 10. There is no quarrel over the proposition of law laid down by the Karnataka High Court in the case of CIT versus T. Narayana Pai, wherein the Karnataka High Court held that the twin conditions prescribed in section 263, that is, the order must be erroneous and prejudicial to the interests of revenue, should be satisfied. Learned Counsel also relied on the decision of the Supreme Court in the case of Sirpur Paper Mills versus CWT and the decision of the Calcutta High Court in Jeevan Lal, which I handed up, and submitted that the commissioner in the instant case had exercised the powers of revision on the basis of the report of the audit party, and therefore the commissioner had no jurisdiction to invoke the jurisdiction under section 263 of the Act. The decision of the Supreme Court in Sirpur Paper Mills versus CWT has no application, as the commissioner there had surrendered his jurisdiction and authority to the Board of Revenue in deciding the questions which were sought to be raised by the company in the revisional application. On the other hand, the Commissioner of Income Tax occupies a unique position in the administrative setup of the department. He is the head of the department in the administrative side, and he is also given the power of quasi-judicial nature under section 263 of the Act to exercise the powers of revision. There is no dispute that there is no right of appeal to the department against the orders of the assessing authority, to the first appellate authority, and the jurisdiction to reopen or to rectify the mistake is subject to the fulfillment of the statutory conditions to reopen the assessment or to rectify the mistake in the order. The internal audit party, on going through the records of the assessment of the assessee, had pointed out certain mistakes in the orders passed by the income tax officer. The report of the audit does not in any way bind the Commissioner of Income Tax, but nonetheless, the Commissioner is empowered under section 263 of the Act to make such inquiry and to find out whether the order of the income tax officer is erroneous and prejudicial to the interest of the revenue. If after such investigation, the Commissioner comes to the conclusion that the order is erroneous and prejudicial to the interests of the revenue, he can pass any order he thinks fit. But where the materials are already available on record, there is nothing which precludes the Commissioner of Income Tax from taking into consideration materials already on record. The apex court in the case of CIT versus Shri Manunatheshwari Packing Products and Camphor Works has laid down the above proposition that it is open to the Commissioner to take into account the materials which come into existence subsequent to the completion of the orders of assessment made by the income tax officer. The report of the internal audit party does not have any binding effect on the Commissioner, and the order passed by the Commissioner shows that he has applied his mind independently to the errors pointed out by the internal audit party and then came to the conclusion that the orders passed by the income tax officer were erroneous and prejudicial to the interests of the revenue. Therefore, it is not a case of the action initiated by the Commissioner on the binding circular issued by the higher authorities, nor is it a case of surrender of jurisdiction in favor of any other authority, but it is a case where the Commissioner had exercised the powers of revision after applying his mind in considering the question whether the orders were erroneous and prejudicial to the interests of the revenue in the revisional application. My lord,
Yes.
Lord, Guwahati High Court Division Bench.
Hmm.
My lord, 2012, Volume 5, Guwahati Law Reports, 722. Commissioner of Income Tax versus BA Plantations. B&A. Lord, paragraph, my lord, 7 and 8. Learned Counsel for the Revenue challenged the view taken by the learned single judge by submitting that there was a clear and patent error in the order of the assessing officer in not taking into account the fact that the assessee had already availed of the same deduction in the earlier assessment year, which was not disputed by the assessee. In these circumstances, the order of the assessing officer could certainly be held to be erroneous. The expression erroneous did not include mere error of jurisdiction, but also covered a case of wrong assumption of facts or incorrect application of law or absence of application of mind. He submits that the law laid down in Rajendra Singh has been explained in a recent full bench judgment of this court dated such and such. He submitted that the mere fact that the error could be rectified or resort could be taken to reassessment would be no bar to exercise revisional jurisdiction if the case falls within the purview of the same said jurisdiction. Mere fact that the audit party had also raised some objection did not affect the jurisdiction of the revisional authority. It was not a case where the revisional authority had substituted its opinion for that of the assessing officer, but a case where the assessing officer failed to notice the factual aspect and made assessment on wrong assumption of facts and without application of mind. We have given due consideration to the submission made on behalf of the revenue. We are of the view that the learned single judge was not justified in interfering with the order of the commissioner passed under section 263 of the Act. Even if we ignore the objection of alternative remedy of appeal available to the assessee under section 253(1)(c) of the Act, the fact remains that an error was noticed by the commissioner in the order of the assessing officer, that the assessee had made claim for same deduction twice, and after noticing the said error, the same was corrected. In these circumstances, it could not be said that such an order was beyond the revisional jurisdiction of the commissioner. Similar objection of the audit party did not in any manner affect the revisional jurisdiction, nor the fact that the error could be rectified by the assessing officer or the assessing officer could have taken resort to reassessment provision could be a bar to exercise of revisional jurisdiction. Now, my lord, one last judgment on this. This is, my lord, Division Bench of Allahabad High Court.
Paragraph number.
Paragraph 28.
Yes.
From a perusal of the notice issued under section 25(1) of the Act, it appears that the Commissioner of Wealth Tax had examined the assessment record of each of the assessees and had independently arrived at the conclusion that the orders passed under section 16(3) of the Act by the Wealth Tax Officer was erroneous and prejudicial to the interests of the revenue. The audit objection was only a piece of opinion which might have been taken into consideration by the Commissioner of Wealth Tax, but his decision is not solely based on the audit objection. He also applied his independent mind, and therefore, in view of the principle laid down by the Apex Court in the cases of such and such, the view taken by the wealth tax officer that the assessment should have been made under section 21(1) of the Act is unsustainable in law. Thus, the orders are not only erroneous, but also prejudicial to the interests of the revenue. Now, Lord, these are on the point that the order passed by the Principal Commissioner, Lord, under section 263 could not be said to have been influenced, Lord, by the audit party. Now, my Lord, so far as the case of change of opinion is concerned, Lord, in my very respectful submission, my Lord, the sheet anchor of anybody's case, my Lord, who tries to make out this case, my Lord, Malabar Industrial Company Limited, my Lord, that has been misread. My Lord, the text of the judgment, my Lord, has been tortured. My Lord, if your Lordship sees paragraph 10 of the report, this is 2000 volume 2 SCC 718. 2000 volume 2 SCC 718. Lord, paragraph 10. The phrase prejudicial to the interests of revenue has to be read in conjunction with an erroneous order passed by the assessing officer. Every loss of revenue as a consequence of an order of the assessing officer cannot be treated as prejudicial to the interests of revenue. For example, when an income tax officer adopted one of the courses permissible in law, therefore, my Lord, it should be permissible in law, and it has resulted in loss of revenue, or where two views are possible and the income tax officer has taken one view with which the commissioner does not agree, it cannot be treated as an erroneous order prejudicial to the interests of the revenue unless the view taken by the income tax officer is unsustainable in law. Therefore, merely because a view is taken and the commissioner takes a different view, it will not be a case of change of opinion if the view taken, my Lord, is unsustainable in law. My Lord, we conveniently forget, my Lord, the later part, and we say that it is one of the possible views. One of the possible views sustainable in law. Lord, I may have some kind of an aberration, my Lord. For me, my Lord, this may appear to be white. I may have a possible view. It is possible for me. But whether this is sustainable, my Lord, this is the question, my Lord, which we put to ourselves. My Lord, that, my Lord, the ITAT has not done. It says it is a view. It is a possible view. If it is a possible view on misreading of a section, it will be a possible view, my Lord. I ask this question to myself. It cannot be a possible view if the view is not possible on the correct interpretation of the section. It has to be sustainable in law, permissible in law. That is what the judgment says. Now, my Lord, whether the view taken was permissible in law. Lord, kindly take 2008 volume 9 SCC 534. Lord, this is Agricultural Produce Market Committee, Narela.
So this is the main point.
Yes, Lord, Municipal Committee.
2008.
Volume 9 SCC 434. What is a municipal committee, my Lord, has been discussed.
Yes.
Lord, Lord, I shall place, my Lord, paragraph, my Lord, 36 straightway. Rather, my Lord, 35 onwards.
Page number?
My Lord, page 451, paragraph 35. 451, my Lord, right hand side is the pagination. Para
Yes.
35. my lord.
Yes.
One more aspect needs to be mentioned. In RC Jain, the test of like nature was adopted as words other authority came after the words municipal committee, district board, body of port commissioners. Therefore, the words other authority in section 331 took color from earlier words, namely municipal committee, district board, or body of port commissioners. This is how the functional text is evolved in RC Jain. However, as stated earlier, Parliament in its legislative wisdom has omitted the words other authority from the said explanation to section 1020 of the 1961 Act. The said explanation to section 1020 provides a definition to the word local authority. It is an exhaustive definition. It is not an inclusive definition. The words other authority do not find place in the said explanation. Even according to the appellants, AMC is neither a municipal committee, nor a district board, nor a municipal committee, nor a panchayat. Therefore, in our view, functional test and the test of incorporation as laid down in RC Jain is no more applicable to the explanation to section 1020 of the 1961 Act. Lord, this will be my submission also, Lord. The functional text, Lord, which was sought to be applied, that they are carrying out the same functions.
That section 16
Yes.
carries out.
Yes, my lord, this will not be applicable.
43W.
Therefore, in our view, the judgment of this court in RC Jain, followed by judgments of various high courts on the status and character of AMCs, is no more applicable to the provisions of section 1020 after the insertion of the explanation definition clause to that subsection vide the Finance Act 2002. The question still remains. Lord, this is very, very important. The question still remains as to why Parliament has used the words municipal committee and district board in item 3 of the explanation. Lord, this is the explanation to the section Income Tax Act. In our view, Parliament has defined local authority to mean a panchayat as referred to in clause D of Article 243 of the Constitution of India, and municipality as referred to in clause E of Article 243P of the Constitution of India. However, there is no reference to Article 243 after the words municipal committee and district board. In our view, the municipal committee and district board in the said explanation are used out of abundant caution. What is the caution, Lord? Next paragraph. In 1897, when the General Clauses Act was enacted, there existed in India municipal committees and district boards. They continued even thereafter. My lord, it is for them which existed then and are continuing even today. In 1897, when the General Clauses Act was enacted, there existed in India municipal committees and district boards. They continued even thereafter. In some remote place, it is possible that there exists a municipal committee or a district board. Therefore, in our view, apart from a panchayat and municipality, Parliament in its wisdom decided to give exemption to municipal committee and district board. Earlier, there were district board acts in various states. Most of these states has repealed those acts. However, it is quite possible that in some remote place, district board may still exist. Therefore, Parliament decided to give exemption to such municipal committees and district boards. Therefore, in our view, advisedly, Parliament has retained exemption for municipal committee and district board apart from panchayat and municipality. Thereafter, our view finds support from the provisions contained in Part 9 of the Constitution of India. My lord, this Part 9 relates to panchayats. Article 243N provides for continuance of existing law and panchayats.
Yes.
In states, inter alia, that notwithstanding anything in Part 9, any law relating to panchayats in a state immediately before the commencement of the Constitution 72nd Amendment Act 1992, which is inconsistent with the provisions of Part 9, shall continue to be in force until repealed by a competent legislature. Then we come to the next part. Part 9A, Lord Municipality. Similarly, under Part 9A, there is Article 243 ZF, which refers to the municipalities. This article inter alia states that notwithstanding anything in Part 9A, any provision of any law relating to municipalities in force in a state immediately before the commencement of the Constitution, 74th Amendment Act 1992, which is inconsistent with the provisions of Part 9A, shall continue to be in force until amended or repealed by a competent legislature. In our view, Article 243N and Article 243 ZF indicate that there could be enactments which still retain the entities like municipal committees and district boards, and if they exist, Parliament intends to give exemption to their income under Section 1020 of the 1961 Act.
So
They ought to have existed, my lord, when this amendment
So this functionality test is.
is, my lord, in my respectful submission, not applicable.
Yes.
And my lord, these are for bodies which existed. They should, my lord, retained. My lord, the Supreme Court says they retained the exemption. They were getting exemption, they are getting exemption, even Lord, if Lordship sees that.
Correct. That's why they use the word if they exist.
Yes, yes,
They exist.
yes.
And if they exist, Parliament intends to give the exemption.
Exemption to them. So, my lord, it is for bodies which are working as municipalities contemplated under the Constitution, for bodies which are working as managing committees, municipal committees contemplated within the meaning of particular acts, my lord, which establish those committees. When, my lord, even the General Clauses Act, my lord, was enacted. Now, my lord, your lordship will take 2018 volume 9 SCC 351.
Yes.
Lord, I will place a few paragraphs, Lord.
I think this is closer to facts,
Yes,
this decision.
yes, yes. And Lord, the next will be more closer, my Lord. I'll be coming close. Lord, paragraph 8. Lord, this is the submission. Lord, what the submission is. The learned counsel for the appellant submits that both the judgments of this court relied on by the High Court for dismissing the writ petition were not applicable and clearly distinguishable. He submits.
So before that, para 2.
Para 2. Very good.
Some facts.
Yes, yes.
What is that authority?
Yes, yes. Definitely. The facts giving rise to these appeals are the appellant New Okla Industrial Development Authority, hereinafter referred to as the authority, has been constituted under Section 3 of the UP Industrial Area Development Act 1976, hereinafter referred to as the 1976 Act, by the notification dated 17/4/1976. The 1976 Act was enacted by the state legislature to provide for the constitution of an authority for the development of certain areas in the state into industrial and urban township and for matters connected therewith. Here it is urban township.
Here it is West Bengal.
New town,
Town Planning Act.
yes, yes,
Under that, this was constituted.
yes, yes, the 79 Act,
79 Act.
yes.
Yes.
Under the 1976 Act, various functions have been entrusted to the authorities. Here also, my lord, in our case also. Notices under section 142 of the Income Tax Act dated 28/7/1998 and 8/8/1998 were issued to the appellant. The appellant challenging the said notices filed writ petition contending that the appellant is a local authority, hence is exempted from payment of income tax under section 1020 and section 1020A, my lord, A was existent then, of the Income Tax Act 1961, hereinafter referred to as the 1961 IT Act. The writ petition was allowed by the division bench of the Allahabad High Court on 14/2/2000, holding that the appellant is a local body. It was held that it is covered by the exemption under section 1020A of the 1961 IT Act. The division bench, however, did not go into the question whether it is also exempt under section 1020. By the Constitution 74th Amendment Act
May not
19...
be required.
Yes.
Now you can come back to para 8.
By right, yes. The learned counsel for the appellant submits that both the judgments of this court relied on by the High Court for dismissing the writ petition were not applicable and clearly distinguishable. He submits that the judgment of this court in Agricultural Produce Market Committee, my lord, the one which I placed, was a case where this court was concerned with the status of Agricultural Produce Market Committee, which was not akin to the appellant in view of the statutory provisions contained in the 1976 Act. Hence, reliance in such case was misplaced. With regard to the judgment of this court in Adityapur Industrial Area Development Authority, it is submitted that this court essentially has considered in the above case regarding the exemption under Article 289 of the Constitution of India, whereas the appellant does not rely on Article 289. He further submits that the Governor of UP has issued notification dated 24/12/2001 under the proviso to Article 243 Q1A, which provision was not considered in the above mentioned two cases. Hence, the present case is clearly distinguishable from the aforesaid two judgments. It is submitted that municipal services are being provided by the authority. My lord, the same submission which was made here. It is a local authority entitled to the benefit of section 1020 of the 1961 IT Act. The constitutional scheme envisages performance of municipal functions even by a body which may not be elected and yet performs municipal functions. Article 243Q envisaged such authority, and also having been recognized such an authority by issuing the notification, it is a local authority and is entitled for the benefit of exemption. There does not exist any elected municipality for the industrial development area, and it is the appellant which is entrusted to discharge municipal functions as enumerated in the 12th schedule under Article 243P of the Constitution. The appellant was not only a creature of the statute, but also has been statutorily charged to perform functions, including municipal functions. The appellant is a local body having local fund, and its accounts are audited by the examiner of the local funds. The appellant also has authorization by law to levy tax in contradistinction to a mere development authority. The learned counsel appearing for the revenue, my lord, these are submissions of the revenue.
I think you straight away come to para 31.
No, my lord, before that, my lord, the para
Before
4,
that-
yes, very.
Before that, all constitutional provisions, etc. Para 31 will be relevant. That's where the crux.
Yes. Should I start? Applying the rules of interpretation as laid down by this court, it is clear that the proviso is an exception to the constitutional provisions which provide that there shall be constituted in every state a Nagar Panchayat, a municipal council, and a municipal corporation. Exception is covered by the proviso that where an industrial township is providing municipal services, like the governor having regard to the size of the area and the municipal services either being provided or proposed to be provided by an industrial establishment, specified to be industrial township. The words industrial township have been used in contradistinction of a Nagar Panchayat, a municipal council, and a municipal corporation. The object of issuance of notification is to relieve the mandatory requirement of constitution of a municipality in a state in the circumstances as mentioned in the proviso, but exemption from constituting municipality does not lead to mean that the industrial establishment which is providing municipal services to an industrial township is the same as municipality as defined in Article 243 PE. We have already noticed that Article 243 PE defines municipality as an institution of self-government constituted under Article 243Q. The word constituted under Article 243 PE read with Article 243Q clearly reflects to the constitution in every state of a Nagar Panchayat, a municipal council, or a municipal corporation. Further, the words in the proviso, a municipality under this clause may not be constituted, clearly means that the word may not be constituted used in the proviso are clearly in contradistinction with the word constituted as used in Article 243 PE and Article 243Q. Thus, notification under the proviso to Article 243Q1 is not akin to constitution of municipality. We thus are clear in our mind that industrial township as specified under the notification dated 24/12/2001 is not akin to municipality as contemplated under Article 243Q. At this juncture, we may also notice the 2 judgments as relied on by the High Court and 3 more judgments where Article 243Q came for consideration. The first judgment which needs to be noticed is Adityapur Industrial Area Development Authority. The Adityapur Industrial Area Development Authority was constituted under the Bihar Industrial Area Development Act 19.
On that judgment, you now go back to para 24. That's where that notification is there. So you'll have to, in your argument, you'll have to substitute new town instead of industrial township.
Yes, yes.
You substitute and now you come to para 24, page 3C. In exercise of the powers under 243Q, governor having right size of the new Okla industrial zone, so declared as an industrial development, and the municipal services being provided by so-and-so authority in that area, please to specify new town development area to be an industrial township.
Lord, the notification here is.
Here,
Yes. $146.
Oh, you see the bill. Where is the bill?
Lord, bill is, I showed to your lordship, the bill is at page 9. Page 9. Yes, 9. Bill is at page 9.
No, there was some reference to that governor's notification.
Yes, the governor's notification, lordship will find at page 146. Lord, there are several notifications. The lordship will find page 144 is the first one. 144. In exercise of the power conferred by section 3 of the New Town Kolkata Development Authority Act, the governor is pleased to constitute the New Town Kolkata Development Authority with the following persons for carrying out the purposes of the New Town Development Authority Act. Lord, page 144 of the bunch.
No. If you come to your stay petition, page 19, in their reply to the show cause notice.
Yes.
On merits without prejudice, so and so, so and so. It may be noted Article 243 Q1. There should constitute every state Nagar Panchayat
that is
for a
quoted.
transitional area.
Yes.
New town has been notified by the governor of West Bengal as a planning area under West Bengal Town and Country Planning Act 1979.
May I just assist your lordship on the notifications, only that. There are
Yes.
notifications, your lordship, and it takes the comparison. The first notification was issued in 1999. When
Under which provision?
under the West Bengal Town and Country
That's
Planning
what
Act
we are
1970.
That is your reply. We are reading your reply to the show cause notice.
There are several notifications.
Maybe
issued.
that's the first of the
First one
notification.
is 26 subject to corrections, 26th August 1999. Before the constitution of the NKDA.
That is what they say.
Yes.
In short, WPTC. Thus, Newtown area and various areas have been subsequently notified by the governor by various notifications which are attached as Annexure A. So, therefore, here also the somewhat a similar plea was raised, saying that notification is there under 243. That they say will not qualify. Now you skip over this Jadavpur Industrial.
Yes.
And come to the finding. Then RC Jain.
My lord, there is a discussion only on judgments, paragraph 33 onwards.
Then para 44, 1020 as amended by Finance Act 2002. A.V. Fernandez, Rajasthan, Rajesh Sakari.
But paragraph 44 is important. Paragraph 44.
No, this is what was explained in agricultural produce.
Yes.
You can come to para 47, I think. Or any other para you want to read?
But it's all, my lord, relying on several judgments. Lord, the
47 refers to the explanatory notes on the Finance Act 2002.
Yes.
Municipal committee dispute legally entitled to so and so. Therefore, not be available to agricultural market societies.
Ultimately, not paragraph 57.
51 also.
After the omission of section 1020A, the only provision under which a body authority can claim exemption is section 1020. Local authority having been exhaustively defined in the explanation to section 1020, an entity has to fall under section 1020 to claim exemption. It is also useful to notice that this court laid down in State of Gujarat versus SR Oil Limited that a person invoking an exception or an exemption provision to relieve him of the tax liability must establish clearly that he is covered by the said provision. It is useful to extract, my lord. Thereafter, my lord, your lordship has the recent judgment also, my lord. Now, reverting back to the explanation to section 1020, these are entities which mean the local authority. The submission of the appellant is that the appellant is covered by clause 2 of explanation, that is municipality as referred to in clause E of article 243P of the Constitution. Lord, in our case, it is not. They don't say it is municipality, they say it is municipal committee. Lord, I have...
Originally, they said Nagar Panchayat.
Yes.
Then they gave up that plea. Then their plea is it is municipal committee.
Yes.
But this omission, effect of 20A omission, that was not discussed by the tribunal, not argued, I suppose.
Yes. No, my lord, omission is something, my lord, which should receive, my lord, serious, my lord, consideration. My lord, on this also, my lord.
We will continue.
May.
When we will continue this issue?
We had indicated in our written submissions before the private. Regarding the
It
amendment.
is there in your compilation,
He's reading it.
page 1.
Yes, ma'am. Page 2.
You go through. Anjan, I keep this inside.
Would your lordship kindly keep it?
Heard in part, what is it? Heard in part.
Yes,
But in
but in
part, but
part
not on Wednesday.
Whatever day you want.
Now that Monday, koro? Monday.
Friday.
Next one is Wednesday week.
We have heard Mr. Om Narayan, right?
Lord, with Mr.
For continuation, I am Soman Bhattacharya.
Friday.
And for continuation of arguments,
Friday.
list on Som's.
Friday. On a Friday.
There may be some difficulty.
Because my Wednesdays, there may be some problem and I may be out of.
Every day there will be some. Starting from tomorrow, every day there will be.
Every. Why, Mala? When I put the question myself.
Friday there will be some difficulty.
Friday I'm here, but Friday.
All right. Let us see. We'll
But
see and
not
give a
on
date.
Wednesday, not on Wednesday.
Not this
But
Wednesday.
Wednesday week, Wednesday week.
Wednesday is will be
Monday.
Monday.
This next Monday. Huh? So you will cite a couple of judgments on which issues, sir?
My lord, one on deletion, my lord, another judgment, my lord, on this point also, my lord, this
Very good.
municipality, my lord.
Urban.
Yeah.
Another is the Urban Improvement Trust. Thereafter, we will. My turn comes. Fantastic.